Hey, please tell me some circumstances. I will agree with you.
My lord, what has happened is, on 3rd, the application came to be rejected. On the very same day, even before I looking into the impugned order, what is being now challenged, on the very same day, the learned trial judge was pleased to frame the charges. And from 3rd, the matter is posted to 9th, tomorrow, for fixing the date for trial. Now, in the event of the case is getting progressed, my rights, the valuable right of challenging the impugned order, would be defeated. That is the only request. Yesterday, in fact, yesterday it was filed. I moved it. We saw to that the office objections are cured. No office objections are there. Unfortunately, it is not been listed. That is the reason. If not, I would have not certainly burdened. Kindly pardon.
Lordship, this matter may be listed tomorrow. Lordship, this matter may be listed tomorrow. We are withdrawing the petition, Your Lordship.
Let's give it.
My lords, interim custody of twin daughters. Yesterday, I moved the matter for summer vacation. Your lordship ordered it to be listed today, but it's not listed. If it can be taken up tomorrow, the trial date is also tomorrow.
My lords, this is a fresh matter.
Obliged.
In respect of custody for the summer vacation, my lords, I have moved an interim order also for an interim prayer. It may kindly be listed tomorrow, my lords.
When is the vacation?
Vacation has already started, my lords. The trial court
You are
has granted
appearing for
from.
whom?
I'm appearing for the father. He comes from Delhi to Bangalore every month for visitation.
So you are the non-custodial parent.
Non-custodial parent, my lords. If it may kindly
Vacation
be.
is not given to you.
It is granted 2 to 6, my lords. Even though I have every month from morning 10 to 6, I am enjoying the benefit of the visitation, my lords. Regardless to that, an order is passed for 2 to 6 only for the summers, and that too only 25% of the summer vacation, my lords.
What is 2 to 6 date?
From 2 p.m. to 6 p.m. only. It may kindly be listed tomorrow, my lords.
Tomorrow.
Much obliged.
13% ಬಂದಾಗ ಇಲ್ಲ. ಅದು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? Twenty 28 to 36 matters are transferred from this court to court hall number 34. Madam, 58 to 63 is also transferred to court hall number. What is that number? 34. So advocates need not wait in this court, can go to that court. Yes.
My lord, I'm sorry, my lord, it is list number 1, my lord, your lordship has said.
Yes, we'll call out. You want adjournment?
No, my lord. List number 1, 35 and 36, my lord, it is there.
You go before that court.
With
Yes, correct. Call out.
total 34, my lord.
Yes.
Please, my lord.
Page 9, number 37 to 39. Page 10, 40 to 49. Page 11, 50 to 57.
Yes.
Page number 3.
Matters to be referred to Lok Adalat. Any objection in any of these matters?
Serial number 5, no objection.
Huh?
No objection. Serial number 5.
No, if you have objection, then you can point out. Otherwise, all matters will be referred to Lok Adalat. Matters are referred to Lok Adalat. Lok Adalat, DALAT ಅಂತ ಮಾಡಬೇಕು, TH ಅಲ್ಲ. Lok Adalat, this spelling is ADALAT, not TH. All matters refer to Lok Adalat. That's all. No, nothing else. Next.
This one, the orders, serial number 1. Right for the petition.
I am for the respondent, my lords. Kindly pass out the matter, my lords. See number 1 and 2, my lords.
All right.
Both the matters. 1 and 2. Grateful, my lords.
Pass over.
Number 3, the orders.
Yes, Mr. Prasanna Kumar.
ASG, my lords, online.
Yes.
No petitioner.
I'm sorry.
Yes, Mr. Senior Counsel. Now you are this side.
That is why my learned friend Rahul told me, sir, your place is there.
Yes, where is the learned ASG?
No, the ASG is online, lords.
My lord,
It should be.
Probably, if my lord permits me, I would like to make one submission. This is a petition for cancellation of bail that has been granted to me by the trial court. I have questioned in a criminal petition, my lord, the legality and correctness of the order of cognizance and issuance of process against me in this very case itself. A coordinate bench of this honorable court has
Of the ED or the predicate offense?
ED.
ED.
ED has ordered a stay of.
Stay is granted.
Therefore, probably the fitness of this may not, if that petition is allowed, this may not survive for consideration. Ultimately, I leave it to your lordship.
You're right.
May I request your lordship is to kindly call it any time that suits my lord's convenience. In fact, that matter is also listed today at 2:30.
Yes, sir, Mr. ASG.
Yes, madam. I joined a little late, Mr. Nagesh. Can you just repeat the request for my convenience, please? For my.
Yes, yes.
Sorry.
He wants you to repeat the request if you don't mind.
No, my request is that the order of cognizance and issuance of process stands stayed in a criminal petition by an order which came to be passed by the coordinate bench of this honorable court. If that petition were to be heard and disposed of, probably this petition may survive or may not survive for further consideration. And that is also listed for today in the afternoon session at 2:30.
Before the next court. Yes, Mr. Raj.
Actually, it is independent. I leave it to my lords, whether my lords want to hear it after that or this. I am ready with the matter.
So you are here, Mr. Raju, or you are not in Bangalore?
I am in the Supreme Court right now, my lords.
I think Delhi weather is pretty hot. You can come to Bangalore.
Yes, my lord, but I'm tied up. I got a lot of matters today. Anyway, I'll definitely like to appear before my lords, my lord.
Bangalore weather is far, far better than Delhi.
Yes, yes.
I had come last week to Bangalore, man. I had come last week to. Of course,
Yes,
I love Bangalore weather. Only thing I don't like about Bangalore.
Raju, I concur with Mr. Senior Counsel that the Bangalore weather is better.
Yes, my lord.
I also concur. Only thing I don't like about Bangalore is traffic. Otherwise, I love everything about Bangalore.
All right. All right. So we'll have this matter after 2 weeks. Maybe by then that matter will get over.
Please.
Grateful.
Any day that suits my lord's convenience. I am the respondent.
I understand. This is for cancellation.
It is for him to make out a case.
So he's also ready. In fact, he's also.
Please.
Had learned Senior Counsel Sri Raju.
ASG, my lordship mentioned ASG.
Yes, ASG. ASG. Senior Counsel, learned ASG Sri S.V. Raju. On behalf of Sri Prasanna Kumar P. for the petitioner. Learned Senior Counsel Sri C.V. Nagesh appears on behalf of Gaurav N. for the respondent. Learned Senior Counsel for the respondent submits that there is another connected matter wherein the proceedings of the Enforcement Directorate is questioned, which is also listed today in the coordinate bench of this court, before the coordinate bench of this court. Hence, it would be prudent for this matter to be taken post disposal of that matter, the above other matter. Hence, call this matter.
But there I have an objection. If that matter goes on for years, this can't, because bail matters can't be adjourned for years to come. If it is not proceeded on some reason today or on the next date, I will press for a hearing of this matter.
After 2 weeks, I will post it. You can ask for it. After 2 weeks.
My lords may say that I am objecting to it being postponed on the grounds of the quashing petition, is that because this is independent, this can go on.
Learned ASG appearing for the petitioner seriously objects to the ground for adjournment and contends that there is no relation between this case which is sought for cancellation of the bail of a respondent as the other case is filed for quashing.
Yes.
Be that as it may, list this matter after 2 weeks for consideration of the present application filed by the petitioner.
Yes. Grateful.
Yes.
Obliged.
Well, in this matter, my lords, I am assisted by Mr. Zoeb Hussain, my lords.
Please repeat that name.
I'll
Zoeb
give the name. I'll give
All
the
right. We'll make a note of it. Zoeb
Grateful.
Hussain. Give that name,
I'll give the name.
spelling and name.
Grateful.
I am for applying, my lord. Insurance company challenging, my lord, liability. Unauthorized passenger carried in goods vehicle, my lord. Unauthorized passenger carried in goods vehicle, seeking stay, my lord. Connected matter, my lordship. My name may be Pradeep, name may be deleted, my lord. BC Shunya Goda name may be shown, my lord.
In connected matter, I appear for appellant. My lord. Process is completed, it is.
All right.
Connected matter. Yeah. Paid recovery. Huh?
What about the notice to respondent number 1 and 2? Who are they?
My respond number 1, my lordship, is presented, my lord, before this court, my lordship.
Yaro?
DS Sridhar, my lordship.
And KV Shyam Prasad, your lordship. On,
Here, DS Sridhar. Who's DS Sridhar?
my friend only, he is not feeling well, so not
Who will take notice?
KV Shyam Prasad will take, I'll take it.
Accept notice?
KV Shyama Prasad.
For which respondent?
Respond number 1, my lordship.
Learned counsel for the appellant is present. Learned counsel Sri KV Shyamprasad.
Yeah.
Accepts notice for respondent number 1.
Please, my lord.
Issue notice to R2.
Please, I will take steps, my lordship.
Pending consideration of IA for delay, IA for stay is taken up.
Pain recovery.
There will be stay of operation execution of the
noticed the
impugned
thing.
order dated 1/9/22 in MVC 3357 of 20. Passed by the 18th Additional Judge Court of Small Causes, MACT, Bengaluru. Subject to the appellant depositing %50 of the award amount
Before this court, my lordship.
for this court within 4 weeks from today.
I may be permitted to withdraw my.
Any objection?
My lordship, we challenging liability, my lordship. Passenger carried in goods vehicle. That's we challenging liability.
The pay and recovery is the order, my lord.
I will file necessary application for objection, my lord. Connected, my lordship. 4.1, my lordship. Kindly delete B Pradeep name, my lordship. Company appeal file BC Shunya Goda.
All right. Work the 4.1 registry to delete the name of learned counsel B Pradeep for R2 and show the name of learned counsel BC Shivanne Gowda. Yes?
Please, my lord. Much obliged.
Yes, we'll call after 2 weeks.
LCR may be called.
Secure records, madam.
Have to take notice to
I am for respond number 1, my lord.
the owner. Liability is on the owner. 1 week time.
Weeks time granted if needful done. Issue notice to R2. R2.
Respond number 2, my lord. I am for the respond number 2.
There are 2.
Yes, my lord. I have handed over the entire file to the respond number
Show
2.
me the acknowledgement for having served.
What has happened, my lord, while preparing the appeal for on behalf of the respond number 2, but since they have taken the entire file at that time itself, my lord, between that I filed the wakalat for R2. That is my
case.
difficulty, my lord.
R2 is the claimant. Who's the claimant?
Claimant is the appellant here only, my lord.
You are appearing for whom?
The driver and owner.
So liability is on you.
Pay and recovery order is there, my lord.
Pay and recover
Please.
against the insurance company.
Yes, madam. I humbly request your lordship, my lord, kindly issue notice to the respondent number 2.
All right. Issue notice to respondent number 2. Court notice to respondent number.
Please,
Yes.
grateful.
Ravi Shankar. A week's time granted if needful done. Notice to R2. Call along with MFA 1496 of 23.
I appear.
Notice to R2 dispensed is for admission. Week's time granted to rectify the
I'll
objections.
undertake to file wakalat for respondents.
This
my lords.
fifth time, you are not interested in the
My lords,
case.
I'll complain during the course of the day. Lord's date, I have complained, my lords. Again, office has raised few objections.
Week's time to comply the objections.
Obliged.
I'll undertake to file wakalat in this matter, my lords,
In which
for
matter?
respondents.
What is your name?
LSM, my lords. LSM.
What is LSM?
Lakshmikant S. Mapari.
Registry to show the name of learned counsel, so and so, who undertakes to appear for respondent, only the sole respondent.
Yes. Yes, ma'am.
The husband and wife.
Don't
both
have your
are
file.
there, my lords.
Lords, I'm the proxy counsel.
Lords, the respondents are two, my lords. They are the husband and wife.
It's RPFC matter. You are appearing for whom?
Respondents, both the
Both
respondents.
both respondents. Yes.
My lordship, I'm appearing for the petitioners in this case, my lordship. My lordship, this is the case, my lord, converted to the writ petition converted to the RPFC, my lord. So the few office objections are carried out because of the interim grounds and all. I need to amend the petition, my lordship, so that it can be removed, my lordship. My lordship, the case is, my lordship, FLW has been issued against the petitioner, my lordship. In that case, my lordship, interim stay may be given, my lordship, so that
You rectify the objections, I will dismiss it otherwise. You know that there is some objections raised
yes, my lordship.
and you are asking for stay.
My lordship, FLW has been issued, my lordship, that's why.
2 weeks time to rectify the
My lord,
objection.
date may be given, my lordship.
Failing which matter stands dismissed automatically.
I may permit it to,
I have passed the order, go and rectify if you want it.
my lordship, my lordship, 1 second, my lordship.
2 weeks time granted.
No, I may allow to amend, my lordship, so that the things can be removed, my lordship. Interim grounds are there and a few other things are there, my lord. This is a converted petition, my lordship.
Converted from WP to RP.
Yes, my lordship.
All right, 2 weeks time granted to rectify.
Yes, my lordship. Date may be given, my lordship.
ಫಸ್ಟ್ ರೆಕ್ಟಿಫೈ ಮಾಡ್ರಿ ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಅದು ಬರೋದೇ ಇಲ್ಲ ಕೋರ್ಟ್ ಮುಂದೆ ಅರ್ಥ ಆಗಿಲ್ಲ 2 weeks time it's a peremptory order granted to you. You want to rectify it, your petition will survive, otherwise it will automatically stand dismissed.
11, I am for the petitioner, my lord. Lordship, may kindly permit to withdraw, lordship, with liberty to file a criminal petition.
What petition?
Criminal petition.
This is only revision petition. What else you want?
Criminal petition.
You are challenging interim order on IA
Please, my lord.
under 125.
Please,
May not be criminal petition, you may have to file a writ petition.
please.
All right, learned counsel for the petitioner files a memo. Seeking to withdraw this petition and liberty to file fresh petition in accordance with law. The memo and the submission are accepted. This petition is dismissed as withdrawn. Liberty is reserved to file appropriate petition.
Please. Achuk.
I'm appearing for respondent number 3, my lord, praying for 2 weeks' time to comply by the office objections. My senior will argue on the matter on the next hearing date, my lord.
What is this? What is this case? Yes?
I appear for respondent 1 university, my lords. This writ was allowed, my lords. In fact, my lords, in order dated 11/7/2023, my lords have directed not to implement the order dated 11/4/2023. Now we have not implemented the order, my lords. The entire issue is the writ was allowed direct.
You are appearing for?
Respondent number 1 university, my lords.
Rajiv Gandhi University.
Yes, my lords.
Yes.
Now the issue is, my lords, the writ was allowed directing the respondent to issue new user ID and password.
Yes.
Now, my lords, now the petitioner institution which is Kormangala Kalaniketan Education Society, was subleased to another society, Prime Charitable Trust, for the period of 3 years. So now the implementing applicants, they have filed an application seeking for the not to implement because they have not given back the society to the original trust, my lords.
The prime group of institutions was taking care of the petitioner institution, my lord. We had taken over it. And then Mr. Raja Reddy, the petitioner, was misrepresenting and has, without valid authorization, used our name, my lord. That's why we have filed the impleading application as well as a review order, because we wanted a review of the order because it was obtained by fraud. Certain objections have been raised and we were not aware of the objections because it's a disposed matter. If 2 weeks time is granted, my senior will argue on the matter, my lord. It's our mistake. We will comply by the objections, my lord.
You have filed which application?
We have filed an impleading application as well as a review application dated 25/5/23 and 24/5/2023.
You are not a party in this petition.
Our wakalat has been returned, my
You are not a party in this petition.
We are an impleading applicant.
I think this is a disposed of matter. You want to implead yourself in a disposed of matter and seek for review.
Today's office note has specifically mentioned that.
All right, argue the matter. Let me consider it.
2 weeks time may kindly be granted, my lord.
Now, what have you done now with that?
No, we have not implemented order, my lords. We don't have any role in this matter, my lords. Only insofar as per the directions issued by this Honorable Court, it was to change the user ID and password.
Correct. Nursing college.
Nursing college. Thereafter, on 11/7/2023, my lords, this Honorable Court directed the university not to implement. So we have kept it as it is. Now it's between the impleading applicants and the petitioner, my lords. Now what their contention is,
The petitioner is not running that nursing college.
the impleading applicant contention is they have purchased that society.
But who's running the college?
No, Prime Charitable Trust. But the lease period was only 3 years. As per the university instructions, the lease period was only 3 years. They have to
call this matter after 2 weeks at request of respondent. Counsel for petitioner is present. Yes.
Grateful.
Because I'm filing one memo with the few documents.
Yes.
Plus this, the application for vacating stay that they have filed and the present application that they have filed for direction, verbatim is the same. Every word, every sentence. So I'm filing a memo that I'm adopting the said objections filed on 1/2, my lords, if I'm not mistaken. Yes.
So vacating stay is filed by
Them.
the respondent.
Yes, my lords.
The stay of the proceedings before the court.
My lords, yes, there was a stay, there is a stay issued by
On the
this
ground
court.
of jurisdiction.
Yes, they filed an application for vacating that stay.
All right.
And that application and the present, they filed an application last time asking for a direction for to implement the order wherein the court has said the father to give his consent. Now the averments are verbatim same.
All right.
So I'm adopting that objections. And I'm also filing one memo, my lords. With few of the documents which are relevant to decide the present application that I filed for interim custody. May I just request your lordship to just
Yes.
plus this is the message that was exchanged between the parties just before the respondent left her matrimonial home. This is on 7th April. In furtherance to my averments, they were planning on a vacation and where to stay. And the next message, they were planning to go for a wedding. This was on 14th April. 18th April is when they have that an argument or a fight, whatever it is. And 22nd April, she leaves the home along with the child and comes to Bangalore. From then on, the father has been allowed to meet the child at the intervents of the court only on 4 occasions, which I have detailed in my application, my lords. Only on 4 occasions, including the directions by this honorable court, wherein the father met the child in the adjacent court for hardly about half an hour to 1 hour. Because the third is the email message in the list of documents that was sent by the father to the respondent mother, asking her to meet once he gets to know that she is settled in Bangalore. However, no effort is made. And she does not allow the father to even enter the apartment and directs the security not even to allow him inside the gate.
What is the application you are arguing now?
Miller's interim custody, which
Which is that application?
Miller's. Dated Miller's 28/3.
IA number Elima.
IA number should be 3, Millards, if I'm not mistaken. Millards?
You are seeking the
person custody.
that is IA number 2.
Because they filed an IA before that, I think that would become 2, if I'm not mistaken.
Your application IA number 2 is for interim custody during vacation, summer vacation, 50%.
Please, Millards, I'm sorry, yes.
That is IA number 2.
IA number 2. Because the father is seeking 50% custody because from the time the mother left the matrimonial home along with the child and settled in Bangalore, he has not been allowed to meet his child at all. Though they filed a memo, which I have, Millards, filed it with a list of documents, saying that they do not mind the father visiting on Sundays between 10 to 2. And thereafter also make video calls. However, nothing has been happening because the mother has not cooperated. He has sent an email requesting her to allow him to video call the daughter. Even on the daughter's birthday, the father was not allowed to even wish the daughter over the phone.
All right.
So my prayer in view of the Supreme Court stay, Millards,
yes,
and the main matter having been kept in abeyance. So my application for interim custody may kindly be allowed, and father may be permitted to have the custody of the child for 50% of the vacation.
When is the vacation started?
Millards?
When is the
Vacation, they said, till 10th of April, the child has exams in Bangalore. Post which, the child is having vacation.
Have you filed that memo with regard to the vacation period?
Millards, they filed it along with their application, the timetable, yes.
Along with the direction application?
Millards, I'll just... objections to the... Yes, Millards. Their objections.
Anyway, there
Filed
is
some
no dispute
documents.
with regard to the vacation commencing from 10th.
10th of April.
To?
I'm quite sure it will be till 2nd of June, Millards. They have not said that, they have just
4th of
produced.
June. Yes.
So my prayer would be, Millards, the father has every right to meet the daughter and spend some time. They cannot be seeking to execute or implement an order that is passed in the family court. And the proceedings have stayed by this honorable court.
Now, what is that order? Take me to that order.
Millards, that order, now their application will have it, Millards. IA number 3, if I'm, for direction. Because they have not produced that order. Plus, that order, your lordship will find it at Annexure D1 in their statement of objections, my lords.
Which is that order?
My lord, statement of objections
Please
filed.
tell me the date of that order, madam.
Date of the order is 19th December 2024.
So what is this order say?
My lord's order says, order directs the father to give consent for issue of transfer certificate.
This is order on IA number 2, is it?
IA number, my lord's, IA number 2, yes. Now the present writ petition is on IA number 5, my lords.
All right.
IA number 3 and 4 was not relevant to this thing. IA number 5 is the rejection of the petition that the petitioner had sought for. That is IA number. And IA number 7 is also an application filed by the father asking for visitation rights, which has not been considered and is kept still pending by the court. Hence, I'm constrained to pray this court to grant me 50% vacation. That is all is my prayer.
Yes.
Lord, the child is 11-year-old. She's a girl child. And Lordship may kindly see now the present application is filed for overnight custody. That we want to take the child to Pune. And half of the vacation which we take. Now, Lordship, I kindly say detailed objection in respect of this application. I filed it in para number last time also. I was not in a comfortable position to read the statement of objection para number 12. There are serious allegations. If it is not the normal case of a father is asking for a child custody, if that is the case, definitely I would have. And that too, these allegations are made in the form of an affidavit. These incidents, particularly towards the child, those certain incidents have been noted on. This is a real apprehension of, as per the petition, respondent is concerned, so far as the overnight custody is concerned. Now, Lordship may kindly see, that being the case, Lordship may kindly some sort of inquiry is required. Probably child also need to be asked about what all the incidents have happened. No such inquiry is conducted either by the trial court, also not allowed to that to happen. Therefore, at this stage, Lordship may kindly see, there are serious, being a mother, there are serious apprehension or mind in respect of overnight custody, because according to statement of objections, and he's in the habit of suddenly he was there is a kind of a split personality. One side is being a very nice person, other side, and all of a sudden it can be turned down to be a very bad situation. So this is the kind of situations child has gone through many times. So that is the reason the safety of the child and the mother, they are forced to leave that city and took a shelter in Bangalore. And Lordship, as soon as I came here, we filed an application before the family court. Lordship, kindly see series of even looks at it. After lapse of, once you get a stay order before this honorable court, simultaneously after lapse of 1 year, he files a GNWC petition intention to drag me to court in Pune. Only for the very well knowing that I am settled down in Bangalore, child is also settled down, child is also doing well in the school, all these aspects. And after a lapse of, you have not even made any effort almost till I filed this petition, or subsequently for a year's time, he has not taken any steps in terms of even to see the child. Lordship may kindly see, so far as Deepavali vacations and others are concerned, I voluntarily given a consent saying that you come and see the child in my presence in Bangalore. That application itself, it shows that, what is the effort I've been made from my side. See to that I don't want to be any kind of barrier or obstacle in terms of relationship to father and child. But this is apprehension in which I clearly stated in my statement of objection what is the reason why the overnight custody cannot be allowed. So this requires, Lordship may kindly, my respectful submission, some sort of inquiry is required by the family court or by this honorable court in case in such applications are considered. And so far as visiting the child in my presence, I have no difficulty. During the vacation time, you can come and see the child. I have no difficulty. But in my presence, that is all my respect, because 11-year-old child, after that incident, she has also shattered in terms of she has mentally also affected the child's thing. So we may seek some time. So let them also not forcefully take this type of coercive steps. See to that it's a matter of at least gain the confidence of the child at this juncture. That is more important. That is the best interest of the child.
The child born.
Child date of birth is
19/1/2014, my lords. 2014.
That is a marriage.
Sorry, my
Marriage
lord.
was in 2011. 12/2/2011.
So till when they resided together and when?
13 years, my lords.
13 years.
13
After
years.
the birth of the child.
Yes, my lords.
11 years.
Child is
14,
11 years.
11. After the birth of the child, 11 years. 14 is when
Where
2014.
they resided?
My lords.
Where they resided?
Pune.
So when did she come to Bangalore?
To 2024, April 22nd.
So 10 years.
After 10 years.
So 10 years both of you resided together.
Together, man.
So you did not have any grievance then.
Except 2 years, there was separation.
When was that?
COVID time.
In COVID. In COVID, I was at my parents' place.
Please tell your client to stand back and not talk to the court unless asked for. Otherwise, she can inform you, instruct you.
Sorry, madam.
Yes.
2 years, there is a separation.
Yes. She can sit down if there is a place for her to sit. Yes, please argue the application for custody. Why it should not be given to the father.
Lordship, I can list so far as this subordinate custody is concerned. I have narrated my objections in para number 12 specifically. There are many incidents in that nature,
Tell me
including
which is that? Where is it? Why?
including locking the child into the toilet.
Please tell me, sir. Show me. What
Para
is
number
it?
12, my lords. 12 of my statement of objection. My lord.
Yes.
Sorry, objection on IA, my lord.
Yes, para 12. When has this incident happened?
This is where while they were staying in Pune, my lord.
Which year? Which month?
This was just prior to, I am not specified in terms of date as such, my lord, but it is while they're staying in Pune, this incident happened.
All vague. You have not given any date. You have not given any year, any month. All of this has suddenly cropped up now after you shifted from Pune to Bangalore.
No, this was there and my petition also mentioned about this, my lord.
Please tell me the date. and
Date I am not, date I am not mentioned, my lord, specifically in terms of specific date I am not
Which
mentioned.
class the child is in?
Child is now in 5th standard, my lord.
She'll be going to 6th, my lords.
Yes.
So far as visiting the child in Bangalore, may have maybe I'm in my presence. I myself has given already a consent to that effect.
Sir, I'm hearing you on summer vacation.
Summer vacation, lordship,
I don't want your
half of the vacation.
leniency to permit the father to see the child in her presence supervised. Please argue on the application filed by her.
No, my lordship,
Where
kindly
she
see-
has filed for 50%
Yes.
summer vacation. Please
Yes, my
argue
lord.
on that. We'll
Lordship,
consider
kindly-
the jurisdiction and other things later on.
Please, my lord. Child is 11-year-old girl child, my lord.
Yes.
In her mother's absence, because this is a very crucial age in respect of the girl child is concerned. Being away from the mother for various reasons. And second thing, lordship, may kindly see, taking him to Pune from Bangalore and in the absence of may affect the child's when all of a sudden, because 1 year they've not been seen each other, and so many other incidents also I narrated in my thing. These under these circumstances, lordship, may kindly see, may not be appropriate for half of the custody, my lord. That is my respectful submission.
All right. That's all.
So far as visitation in Bangalore is concerned, I am already given a consent. I will continue to do that, lordship's directions.
Yes. Where the child is present to the court.
Child is having exams, my lord. That's what she's till 10th, my lord.
To agree to send the child voluntarily? Agree for something together, both of you, on summer
In
vacation?
Bangalore, I have no difficulty,
On
my
summer
lord.
vacation.
Summer vacation, I have not, I mean, this is the condition in which it is said, and I have serious apprehensions, my lord.
Work out. You have produced any material to show any abuse, physical, mental, or torture and otherwise? Any complaint lodged by you against the father?
No, there are incidents which happened when he came to.
Filed any complaint?
No, I have not filed any complaint.
Any email, any material?
No, before the court, I have filed it.
Any
my lord.
WhatsApp communication?
WhatsApp communications are there, my lord.
To the father?
No, father, I left the 22nd itself. I left, my lord, because I was
When
forced
did
to
you
leave.
leave? When did you leave?
27th of April, my lord. After that, I filed
20?
of 2024.
27th April?
22nd of April 2024.
22nd April 24.
A lady to leave a house and in normal circumstances doesn't happen, my lord, because of there is a threat to her life. Because there are police officers and other influential persons are there
All
in the
right,
family.
nobody is forcing you to go and join the husband. This court is not inclined in asking you to go and join. Why the child should not go and meet the father? Yes, Varkoli. Anything else?
Milords, I have produced photographs, in fact, to show, Milords, in my objections to their IA filed on 1st February 2025.
IA3.
Milords, IA3.
Your
1st of February
Your
2025.
objections to IA3.
Yes, Milords. I have produced some photographs. Just very few, Milords. These are very few. I have a bunch of them. The whole family has been traveling, going to the native place, enjoying festivals. The child is extremely close to the father as well as the mother. And the fee receipts that the father has paid, the entire school fees from the birth of the child, whenever she was admitted to the school till now. In fact, she has written.
So apart from this child custody petition, is there any other petition between the parties?
Milords, he has filed a petition in Pune. She has filed it in Bangalore.
For what?
Same custody, Milords. No other petition is pending.
Only child custody.
Only child custody.
So no divorce, no maintenance is
No
filed.
maintenance
No
is pending in my
maintenance
lord.
is filed. I am not sure.
Filed by the wife?
Wife.
We have not received any information on that.
So education expenses are all paid by the father?
Owned by the father, yes.
So this year I've paid it, my lord. This year not even a single
Because you
file.
have come to Bangalore with the
Yes,
child.
ma'am.
I know it's not relevant, but during COVID, when she had pandemic, Milords, in fact, she has written she's a content writer. She has written a book itself on praising the husband and how he saved her.
Barcode.
My lord, one submission. Child's examination gets over 10th. Lordship may kindly have an interaction before passing any such order. The child, because it's a girl child, maybe have an interaction with request honorable court to have an interaction with the child before passing such. Consent of the child is also important.
Because they've been deliberately delaying this for, I do not know for what
When is the
reasons.
exam coming?
10th it gets over.
10th. Already. Keep the child present on 15th.
20th.
15th.
15th.
It's okay.
17th ಆಗ್ಬೋದಾ ಸ್ವಾಮಿ?
ಇಲ್ಲ. 15th.
Because in fact, Milords, may I just point out one line, Milords, what they themselves have said, that the child, she likes the fake persona which petitioner displays during every visit. So they also admit that the child is liking though it is a fake persona is what they say. I do not know why they are doing this to keep the child.
Fake persona
Obviously, of the petitioner father. They feel that he is showing fake persona of love and affection, but however, the child is liking it.
All right. You keep the child present.
All right.
15th, 2:30.
Not 2:30.
2:30.
Not 2:30. 4:30.
4:30.
Yes. Heard learned counsel for the petitioner. Learned counsel for the respondent. Would the learned counsels are requested to keep their respective parties present. The respondent mother is directed to keep the minor child present before the court. 15th April at 4:30 p.m.
Great.
It's made clear, Barkoliman. It is made clear that the respondent shall not take the child out of the jurisdiction of the family court, Bangalore. Full stop. You will not take the child out of Bangalore.
I'll give an undertaking.
No, I have passed an order.
Please, madam.
You violate that, you are in contempt.
Because interim stay may kindly be.
Interim order extended.
Great.
My lord, appear for the petitioner. My lord, in this matter.
Yes, sir.
Have you filed the affidavit?
Yes, my lord.
Have you given a copy?
My lord, we have seen it. It appears we are not filing any objections or anything to it because it's a matter between your lordship and your lordship had passed a direction how she could make a scandalous remark against a counsel in open court in the presence of her counsel. A reading of that affidavit, that issue is not addressed at all. That I leave to your lordship because it was contempt in the face of the court which happened here. They have not answered that. She has not answered that question. My lord, now my issue is as far as the child is concerned. Well, when the child goes on weekend custody, the child is beaten and abused. I have produced pen drive with a transcription of what is happening. And they have not refuted what has happened. The contents, the affidavits also filed.
My lord, I have bought the objections and the written arguments and I have not done anything as that. I've taken care of my child well even this weekend and sent him back on time.
Please wait, let him complete. When senior counsel is arguing, you need not interrupt. I will give you opportunity to address arguments. Yes?
My lord, point number one is the child is being beaten and abused when she takes the child on Friday evenings and brings him back on Sunday. The child's voice on the telephone has been produced on a pen drive with a transcription. They have not refuted what is said. Subsequently, they have not given the child any means to communicate even in the need when he needs help. Two, in all this which they have filed, they have not addressed the issue. They have not denied that the child is undergoing tuition. They have not denied that the child needs the tuition because of certain reasons. And they have not even said, okay, I'm taking the child on Friday. What is the alternate I'm going to do to protect the child? They have not said anything about that also. My submission therefore is like this, my lord, that all that I said was instead of Friday evening, take the child on Saturday morning at 11:30, bring him back on Sunday evening. This is all that I asked. Though we filed the writ petition challenging the order, the modification I asked was, yes, mother also wants to see the child, fair enough. But now, the fact that after the last time when your lordship had an interaction with the child, and the child, she took the child home, this event happened, which is placed on record, and your lordship may consider that. Because ultimately, your lordship now parents patria jurisdiction, my lord, because we are apprehensive about normally, I don't know, maybe the mother in a fit of anger has hit the child, whatever it is, but we are apprehensive about the child. Two things are happening. One is the child is being beaten. Two, the child is losing out on tuition. Both ways, it is not good for the child. As far as the other issue is concerned, of her making that remark in the open court, that is between your lordship and her. She has filed an affidavit which doesn't
that
answer.
we will deal with that later.
No, I don't. That I leave it to your lordship.
Now, what is the urgent application?
Urgency is, my lord, Fridays. Every Friday, 4 hours are lost. Which I'm saying, don't lose. Take the child at 11 o'clock. Why do you take the child at Friday? Take it Saturday morning. We will get the tuition teacher to come a little earlier. Take the child at 11:30.
All right.
That we can do for an interim measure. Then we will see what is to be done. Because the other aspect which I had also submitted to your lordship that day, your lordship, my lord, she has committed contempt of the court. She has not answered. She has not filed an affidavit answering your lordship's specific direction. Till she purges the contempt, she should not be allowed to take a benefit of orders of this system. When you don't respect the system, You cannot take benefit of orders of this system. That's all.
Yes.
My lord, I've filed for objections and written arguments, and I've also, I mean, whatever the, after I've received family court orders, they have harassed me on every visitation. Whenever I've gone to pick up the child, whenever they have come to pick up the child, he comes with his brother, he abuses me, and then he threatens to like finish me off. All of that abuses are given, and then the child is handed over, and the child is given a small phone, and he advises the child right in front of me, saying that after you get into the apartment, you have to call me and cry. I will call the child welfare society, and I will save you. And ask your mother to write emails to me that she can't handle the child. He'll fill the child, and then he'll leave the child and go. After which the child starts crying. Not even 1 minute after I'm picking him up, and after that I have to console him, and I feed him, and I take care of him, and then he's fine with me, my lord. I'm taking care of him as a mother. Their contention is only to like cut ties with me. This is going on from 2018, this harassment, ongoing harassment. I also went back. First set of petitions were over. I said like I don't want anything. I'll adjust and stay in the house. I went back to their house. I started living in the month of May 2022. In 18 months, they planned up everything. They again threw me, just holding back my child. And from then on, this is going on, my lord. And family in the family court, unfortunately, I didn't get back my child. But thankfully, I've gotten visitation, and that also they want to cut short my visitation and not let me see my child peacefully, and not even let me have a peaceful visitation. And I've been taking care of his studies from a very long time, so I can train him is what I'm trying to tell, but they're not able to understand. They're just trying to harass me in all this, holding the child as a pawn. I've filed a detailed objections and return arguments, my lord. Can I submit?
Yes. You have submitted already?
No, my lord. Now I'll submit.
Arguments to which application?
For writ petition 5229 and writ petition 5271 bar 2
You
2025.
file it in the registry, give a copy to the other side. Nobody is stopping you from filing.
I have bought another copy to give it to them also.
Why these two petitions are filed, Mr. Senior Counsel?
One is weekend, one is vacation. Idenaitu, first time the court, family court had rejected her applications.
Two different applications.
First, the family court had rejected her application. Then it came up before your lordship. Your lordship said the family court had not interacted with the child, sent it back. On going back, the family court doesn't ask the child, do you want to stay with your mother? How is your mother? How is your sports? How is your school? And passes an order completely different from the earlier side. Therefore, we challenge both those orders. That is also crucial to please see how there was no change in circumstances between the time the first order was passed and the second order was passed. But in fact, I've got a recording. If I could play it, I'll play it now itself. What the child undergoes.
Who has recorded this?
Father has recorded, and I filed it here. They have not refuted that.
Where was this recording done?
When the son was speaking, on his telephone is recorded. Out of that, I have put it just for the benefit of the court. And in fact, on a pen drive, we have filed it with a certificate that has and a transcript. That was when we served a copy of this transcript that afternoon, minutes after we served a copy of the transcript, that unfortunate incident happened in open court. That has not been refuted.
What was the need for the father to record the conversation?
Because the child is shouting, my lord. 8 calls have come from the child saying that mother is beating. She's standing at the back and laughing, seeing me crying. But this is what is happening. I'm not for a moment saying husband and wife can fight. They can do what they want. But today it is within your lordship's. The child is under your lordship's jurisdiction. Lordship may take whatever steps. In fact, they say alienation. Why will I agree to the child going and meeting the mother from Saturday morning to Sunday evening if I want to alienate? That was not my intention. I'm only protecting the child and saying that don't hit the child. Let the child do his studies. He's going into 4th standard. That's all I'm saying. There is no question of alienation. If it was alienation, I would have been fighting tooth and nail not to give custody. Here, I myself am saying, please take custody, but don't do it on a particular time.
My lord, he has been tutored to speak like that, because if I had to beat him, I wouldn't give my phone and then continue with the conversation. I was just thinking the child is innocent and he's just playing. And this has been put as a record. I didn't know that they are collecting proof against me. my lord. Like he was doing that, and I was like finding it very funny as a mother as to why he's like, suddenly all of a sudden over phone he's acting that way, and that's the reason why at the background I was
All right,
just.
you can come at around 2:30 to the chamber. Maybe I can hear that video recording or audio recording.
Yes, it's
Both
already
parties.
there in the file. We filed it.
I'll hear that in front of her.
Yes, yes.
You can come to the chamber. You are represented through a council or you are?
No, my lord, our counsel is retired.
13%. All right. You can come to the chamber at 2:30.
Very well.
My lord,
The
can I
ins-
submit the objection?
ಕೊಡಿ.
ನಮಗೊಂದು ಕಾಪಿ ಕೊಟ್ರೆ ಚೆನ್ನಾಗಿರ್ತದೆ.
He has to. She will give you. ಕೊಟ್ಟಿದ್ದಾರೆ. Last time ಬಂದಿತ್ತಲ್ಲ. You given your identity for form
Yes, my
A
lord.
and B.
Yeah.
Where is the form A and B?
Here.
Not here. ಕೊಡಿ.
ಅದು ಅವತ್ತೇ ಕೊಡ್ಬೇಕಾಗಿದ್ದು ಇನ್ನೂ ಕೊಟ್ಟಿಲ್ಲ. ಇವತ್ತು ಕೈನಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ.
No, there was some objection raised by the party.
I know it was raised before this.
Correct.
Last time they said course of the day will file.
Mr. Senior Counsel, party in personally, sometimes they don't know what is.
No, my lord, I am not. I don't even bother whether she's filed form A or B. All I'm saying is, every time she says I'll do it.
No, this is precisely the reason. If you will agree, we did not have this party in person committee earlier.
Yes.
Prior to 2018.
Yes.
Anybody could come and argue.
Then because of certain unfortunate
Yes,
incidents,
this is
all
the
this
reason we
became
have
missed.
constituted and
Yes, yes.
framed certain rules and regulations. And they have to comply with it.
ಏನಾಗ್ತದೆ ಅಂದ್ರೆ, my lord, if I may say, ಇವಾಗ tomorrow is the last day for this week. Visiting starts again. There seems to be a system to bring it to the last day and then go to the next week, so that 3 days again. I am not, my lord, the mother should also be worried about the child. I am only a counsel here trying to bring facts to your lordship's record. ಆಯ್ತು ಬಿಟ್ಬಿಡು.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ. Two sets are given.
ಎರಡು ಪೆಟಿಷನ್ ಇತ್ತು. 2:30, my colleague will be
2:30.
instructing counsel.
Yes,
She'll play it. Grateful.
can come at 2:30. You have received that copy of the objection statement?
Yes, yes.
Well, the
He says
Learned Senior Counsel Sri
written arguments ಕೊಟ್ಟಾರ, objections ಇಲ್ಲಿ ಕೊಟ್ಟಾರ.
on behalf of Sri G.K. Bhavna for petitioner is present. Party
That's okay.
person Srimati Sweta D. Rao is present. She filed statement of objections.
We have received copies, statement of objections and written arguments.
Statement of objections.
In both petitions have been received.
Written arguments in both the cases. Copy of it is served to learned counsel for the petitioner. Full stop. Parties shall keep the minor child. The parties shall keep themselves present in the chambers of this court at 2:30 p.m. today.
My lord.
Docket for the petitioner is
Lord, this matter pertains to one application that was filed by the husband petitioner here in Malad under Order 11, Rule 5, seeking the assets and liabilities from the DPAR or the government, since the respondent wife is a deputy superintendent of police. That application comes to be turned on by the Learned Family Court. Subsequent to that, my lord, I am before this honorable court seeking the said document to be made available to me. On the last date of occasion, my lord, your lordship had directed to keep the party present. Following the directions of this honorable court, my lord, the petitioner is very much present before this honorable court. But before that, my lord, may I make two legal submissions if your lordship permits me? The last date, my lord, I think a learned senior counsel had appeared in the matter. I had not had the opportunity to see the file, my lord, because the objections were served to me on that very particular date. If your lordship may kindly come to their objection statement, my lord, where annexure C, page number 55. Annexure A, sorry, my lord, page number 11, your lordship will get it. This is the assets and liabilities that they have filed.
Annexures.
Annexure A, my lord, in paragraph number 11. Page number 11. Annexure A of their objection statement.
My lordships, kindly, my lord, there's one submission. Previous date of hearing, my lords had guided us to explore if there is any possibility of settlement. If they are answering, my lords, on the possibility of settlement, this will not survive for consideration.
That's the reason, my lord.
Let them, my lords, first
I just
clarify if
wanted
there
to
is any
make
concept
that-
of settlement or not. Because as of last evening, my lords, we ourselves had approached them. There was no communication from their end seeking any possibility of settlement. As of now, my lords, let them first clarify on the stand of whether the petitioner herein is willing to settle the matter amicably or
I'm
not.
open to settlement, my lord. Now,
What is the proposal? My lord?
a DYSP or an assistant commissioner of police shall have that much more extra responsibility to come clean before the honorable court. Last date of occasion, my lord, a lot of things were harped upon that everything has been produced in a domestic violence case. Already assets and liabilities have been produced. Hence, there is no question of seeking for these documents from the DPAR. However, my lord, their own document at page number 11 at annexure A, my lord. If your lordship could come to running page number 12, certain aspects I would like to bring before this honorable court where why I am seeking this document because
Simple. Why don't you? Simple thing is we are trying to see whether
Yes.
you want to settle the matter. You want
Please.
to argue? You want to
No,
come?
no, my lord.
You
First-
can say
first-
so. I will record it and argue the matter.
no, my lord. First, we will explore the possibility of a settlement. If
Why are you beating around the bush? This court made it very clear by way of an order that you will explore the possibility of settlement.
please, I've kept the
With regard to the child maintenance and visitation, provisions can be made by this court.
please.
To do that, and time and again, you did not keep taking the avocation of the respondent as to what she is working to put her down. You can mention as respondent.
Please,
This court knows what is her status.
No, please,
Don't
please.
demean the respondent. You can say respondent. You need not keep on telling what she is. If you want to settle the matter, you settle. I'll call it at 2:30.
Please, my lords.
Thereafter, if you want to argue, you can argue the matter.
Lord, on the last date of occasion, your lordship had pointed out two things. Whether I'm ready to maintain the child, my lord. That
I'm not, you need not tell me. You can discuss outside.
Please.
You can come into some settlement yourself if you are agreeing and give a joint proposal or a separate memo by yourself. If it is agreeable for both of you, well and good. Otherwise, I'll pass orders.
Very well, my
No
lord.
difficulty to pass orders.
I will have the discussion outside the court.
Just have,
Parties
meet
are
your-
present, my lord. We'll
Meet your friend outside, sit in the room and we can provide you a room. You can discuss and then get back at 2:30.
Very well.
Either way, you agree, you don't agree. What is the urgency now on the issue that you are going to argue here? What is the urgency?
No urgency, my lord.
What is the order that is in question?
The order that is in question is, my lord, I had filed an application under Order 11, Rule 5.
That is summoning of the records.
Summoning of the documents. They had
That is
made
for
a-
permanent alimony which she has demanded.
Yes.
We'll consider that. That is of course an option available to you if you want to withdraw that.
Please, my lords.
That
I have
also is available.
I have instructions to that extent. But let me just.
You have to see in a wholesome whether you can settle it. Considering the interest of your client, keep that interest intact, put it in terms. If it is agreeable, then thrash it out. What's the point in unnecessarily wasting your precious time before this court? They are only 35 years and 33 years. If you are able to live, very well. Not able to live, part ways. Why you want to waste your time and waste the time of the court?
Very well.
Petitioner and his mother are present. Respondent is present. We'll
Where is
talk.
the child?
Child is also there, my lords. She is about 2.5 years old.
Not present here.
She is not present. We have not brought her. Please,
Not summoned her also.
please, my lords.
Mathadi.
2:30.
2:30.
Oblige.
My lord, I'm appearing for the petitioner in serial number 17. May I kindly request for the matter to be passed over, my lord? And
give you a
inform my
pass.
lord-
I am for the response. Senior counsel is on VC, my lords.
Where is he?
Senior advocate Lakshmi Angar is on VC.
Where is she?
Karitira.
Your Lordship.
This is the matter that was taken up last week, Your Lordship, wherein she was permitted initially to travel and be present on Tuesday. Subsequently, certain submissions were made in the chambers. Your Lordship, Your Lordship asked us to be present today.
Yes, this is that matter. Madam, this is the. You have to. I think you have two systems. You have to exit from one.
There's only one, Your Lordship.
I am also logged into.
No, there is an echo. That's
Your Lordship, not my system.
What's the difficulty for you? Physically, madam.
Your Lordship, I shall be present, Your Lordship. We were informed last evening by the other side that they would want a passover for 2:30. That is why, Your Lordship. Otherwise, we'll be present.
Please.
Next.
Case below that annexure F, that the registry directed me to file a typed copy. The relevant portion, my lord, at page 98, that the order only for that particular aspect I am relying upon.
3 objections.
The 2 objections I am seeing.
How many you are seeing is not the.
That I have downloaded and typed copy of annexure F. That annexure B I have to stitch properly. I will do it, my lord. That annexure F, my lord, it may be overruled for the present because that the relevant portion is typed portion that page number 98. The others copies I have already served.
What's the urgency here?
That urgency is with regard to that maintenance that Your Lordship, I will correct it and I will the matter be listed for preliminary hearing on 15th. By that time, we will correct all other things.
List this matter on 15th.
15th, my lord.
In the meanwhile, learned counsel for the petitioner to rectify the objections. Copy.
That insofar as annexure F, my lord, that it may be
Served to
overruled.
learned counsel for the respondent, which is acknowledged.
The annexure F, it may be overruled.
Annexure F is overruled for the time being.
Oh, bless me.
This is a wife's petition where the husband is seeking for nullity of marriage.
There are 4 objections.
Because all are complied. There are that is certified copies. I think only regarding the pagination, which I will do it, my lords. And online, there is no objections that has been reflected. I think there is only with regards to probably the pagination, if I'm not mistaken, which I will comply after the.
Yes.
Lords, may I? The parties were married, my lords, 2018, April.
What is the order you're questioning?
My lords, IA5. IA5, your lordship will find it at my lords, annexure E. Barely after 2 months,
Who's the
wife goes for to her parents' house for Ashada. And thereafter, her husband initiates a petition. And then he files this application, my
You're
lords.
appearing for the wife?
Appearing for the wife.
All right. Petition is filed by the husband.
Nullity is filed by the
All
husband.
right.
Annexure E, my lords, is IA number 5, where the husband, my lords, makes a prayer. This honorable court be pleased to direct the respondent to undergo a medical examination by a panel of doctors of a recognized government hospital regarding to assess her psychological health for the effective adjudication of the case. Plus, my objections, my lords, is at annexure F. I do make a formal objections, and however, at the end, my lords, at page 81, para number 14, my lords, after that, the respondent has no objections to undergo the medical examination in order to.
Application is allowed.
This application is allowed. The husband's application.
You're appearing for the
wife. Plus, may I just
yes, so what is
read the relevant part of my objections at page 81. The respondent has no objections to undergo medical examination in order to assess her psychological health subject to the fact that the concerned psychologist is appointed with the consent of both the parties. This objections of the wife does not find place in the impugned order at all. The family court, my lords, instead of appointing a psychologist, passes an order where your lordship will find it at page 87, my lords, relevant portion of it.
I have it.
The respondent is directed to undergo counseling and medical treatment at psychiatric expert at NIMHANS. Now, this is what the wife is aggrieved about. She is a software engineer. She is actually B distinction, working in Cushman and Wakefield for about 10 years as a senior manager. So obviously she said that I do not have any objections to, provided it is somebody is appointed with consent of both the parties, that is all.
Where is your objection statement?
Milords, objections is at annexure F at page relevant is 81, Milords. 81 after para 14. Page 81.
Para?
Para number 14 after that, Milords. Ink page 81.
Yes, para 14 is the last para.
Yes, Milords. Just right after that, A.
Yes.
The respondent has no objections to undergo medical examination in order to assess her psychological health, subject to the fact that the concerned psychologist is appointed with the consent of both the parties.
Yes.
To this, we have absolutely no issues.
Yes.
However, she has been directed to go for medical treatment itself.
Probably the family court doesn't know the difference between psychological assessment and psychiatric treatment.
Exactly. That is where the wife is aggrieved at, and that is.
What is the allegation made against the wife?
Milords, that her mental framework is not good. She was hallucinating during the period of stay, hardly about 2 months. That is all.
When is the marriage?
Milords, marriage was in April 2018. After 2 months in July, she goes to her parents' house for Ashada month. And they refuse to take her back after that.
But heard learned counsel for the petitioner. A week's time is granted to rectify the objections raised by the registry. Issue notice to respondent. Counsel for the petitioner is permitted to take out notice to the respondent by way of hand summons, and so also other modes of communication, including serving a copy of this petition to the learned counsel representing the respondent before the family court at Bengaluru. Meanwhile, there shall be stay of operation and execution of the operation of the impugned order dated 11/9/2024 in MC 4170 of 2018, passed on IA number 5. Till next date of hearing. Yes, this matter after 2 weeks.
2 weeks, plus hand summons, I think may not be necessary. I will.
When is the next? When is the next date of hearing?
Plus next date is on. I have not. I think it should be after vacation, Milord. But that's okay. I'll serve it, Milord. I'll serve.
Permitted you to serve on the council.
I'll do.
And also send email communication.
I'll do that. Great.
This is Rangi Gowda. Notice to R1 dispensed. Issue notice to R2. Memo accepted. R1 dispensed Mantala, notice to R1 dispensed. Memo is accepted. Issue notice to R2. on main and IA. On main and IA. Just went Gurudev.
Yes, I appear for the appellant. There is a delay of 46 days in filing the
IA1. Who's appearing? Where is Madam Harini?
I appear for the respondent. Respondent in chief.
It's not screening. Reduce ಆಗಿದ್ದಾರೆ ಅವರು I think Yes, madam, any objection? We'll allow this application, IA 1 of
Yes,
24.
my lord. It may be allowed, my lord.
Please reduce your volume, you're too loud. IA 1
Yes,
of
ma'am.
24 is allowed, delay of 46 days is condoned. Is this matter for admission? You're deposited? You are claimant,
For the claimants.
petitioner. Next. Yes, Jagdish.
For the appellant in this matter, my lord. Case of injury, my lord.
Notice to the respondent pending consideration of IA 1 for delay. IA 2 for stay is taken up.
My lord, on submission, I have deposited the entire amount before the execution court, my lord.
Before the
MSCT, my lord.
Madidira?
With interest, I have deposited, my lord. There was execution, my lord, I have deposited. I have a copy of.
More than 7.5 lakhs.
Please, my lord.
There shall be stay of operation and execution of the impugned judgment and award dated 8/2/24 in MVC 3399 of 21, passed by the 9th additional civil judge, small causes and additional MACT, SECH 7, subject to the appellant depositing
I have deposited, my lord.
the award amount. Full stop. Appellant submits that he has deposited the entire award amount. Registry to verify.
I have
Madidira?
MSCT, my lord.
The tribunal to verify.
Not to disperse, my lord.
If the amount is deposited, the same shall be kept in FD in a nationalized bank till further ordered.
Much.
Issue note heard. Issue notice to respondents. Pending consideration of IA for delay, IA for stay is taken up. There shall be stay of operation execution of the impugned judgment and award dated 16/11/24, MVC 329 of 23, passed by the MACT, 18th ACJM, Small Causes Court, Bangalore City, subject to the appellant depositing 50% of the award amount.
Inclusive of statutory deposit.
Huh?
Inclusive of statutory deposit.
Inclusive of the statutory deposit before the tribunal.
Before
this court within 4 weeks from today.
And
On
afterwards, your
deposit,
lordship.
the said amount shall be kept in FD, the nationalized
Yes.
bank.
Yes, sir.
Petitioner, my lord. IA filed by the extension of time, my lord. Maintenance order, my lord. Because honorable court stay the order dated, my lord. 29 January 25, my lord. Some inconvenience, mother is suffering from the stroke, my lord. That reason I not deposit the amount, my lord. Kindly to 2 weeks time granted, my deposit the amount, my lord.
So that's why you have not taken out notice also.
Notice I have paid, my lord, but in incorrect address reason, my lord. I paid the RPD, my lord. Second.
All right. Learned counsel for the petitioner has filed IA seeking extension of time to deposit the amount ordered by this court dated 29/1/25. Full stop. I have perused the reasons assigned in the affidavit annexed to the application, being satisfied with the same. 4 weeks time is granted.
Yes.
To comply with the order dated 29/1/25. Failing which, respondent would be at liberty to execute the order.
Please.
4 weeks.
Please.
If not needful done within a week's time, issue notice to respondent.
Appear for the petitioner, my lord. IA number 1 is filed seeking for stay and IA number 2 is filed seeking for continuation of 6 days delay in filing of the petition. My lord, the matter, the husband's petition against grant of additional maintenance. Now, interestingly, my lord, additional maintenance is granted even after permanent alimony is awarded to the wife under a compromise petition. Now, interestingly, my lord, if my lords may come to page number 32. This is, my lord, the compromise petition filed between the husband and the wife in MC proceedings for divorce as well as restitution. Both were clubbed. If my lords were to see clause number 8, which is in page 33, my lord, G.J. Satish, who's the petitioner, who's also the petitioner in this petition, in MC so-and-so and respondent in so-and-so, has paid a sum of 25 lakh to his wife, respondent petitioner, Srimati PC, towards Manasa PC, towards permanent alimony to herself and her aforesaid minor child, Achintya. Manasa, respondent so-and-so, has accepted the aforesaid permanent alimony of 25 lakh on herself on behalf of her minor child. Clause 10, Manasa and respondent has agreed to take care and custody of the said minor child Achintya permanently. Now the last clause, not parallel, clause 11, Srimati Manasa has also agreed to get the maintenance case filed by her for herself and on behalf of her minor child in criminal miscellaneous 36/19 dismissed, which is pending before the Honorable Court. Likewise, she has also agreed not to press the case against the respondent filed under DV proceeding before this Honorable Court. Now, by virtue of the compromise petition, my lord, she received the amount as permanent alimony for herself and the minor child. She agreed to withdraw the 125 proceedings that were instituted. She acts on this and withdraws the 125 proceedings as well. Now, my lord, this compromise petition culminates in the judgment and compromise judgment in decree, which is in page 35. Thereafter, my lord, within 1 year, the wife of this compromise petition in page 69 is the petition, my lord. Through the minor son, the wife files a petition under 125 seeking maintenance of 50,000 rupees, alleging educational expenses and requirements for the minor child. My lord, my submission before this Honorable Court is, once a compromise petition is filed accepting permanent alimony for herself and the child, she cannot go back on it. And second, my lord, is that once permanent alimony is received, the maintainability of another petition under 125 is not maintainable in view of the judgment of the Honorable Supreme Court in Rakesh Malhotra. May I please pass on the judgment of the court?
So where is the impugned order here now?
Impugned order is in page number 12, my lord. The court has granted 10,000 rupees as additional monthly maintenance. Interestingly, my lord, in the petition, the wife does not disclose the permanent alimony. And even the Honorable Trial Court does not look into the question of whether once permanent alimony has been received, will an application under 125 be maintainable. Instead, in paragraph number 26, my lord, which is at page 27, the trial court merely relies on the bounden duty of the father and the moral obligation to look after the minor child. The court does not deal with this question at all.
Yes.
If I may take my lord through the decision of the Honorable Supreme Court, paragraph number 11. Now, this petition arises from a permanent alimony granted in terms of section 25 in a contested matter. In our footing would stand at a better pedestal given the fact that it was by mutual consent. Be that as it may, my lord. Paragraph number 11. Since Parliament has empowered the court under section 25(2) of the Act and kept a remedy intact and made available to the party concerned seeking modification, the logical sequitur would be that the remedy so prescribed ought to be exercised rather than creating multiple challenges of remedy seeking maintenance. Next part is, my lord, what I'm relying on. One can understand a situation where, considering the exigencies of the situation and urgency in the matter, a wife initially prefers an application under section 125 of the court to secure maintenance in order to sustain herself. In such matter, the wife would certainly be entitled to have a full-fledged adjudication in the form of any challenge raised before a competent court, either under the Act or similar such enactments, but the reverse cannot be accepted norm. What it states, my lord, is once the proceedings comes to an end and permanent alimony has been accepted, 125 proceedings is not maintainable. This aspect has not been considered by the trial court, which may require interference by the hands of this Honorable Court. In this judgment, my lord, the Honorable Supreme Court goes on to consider the application on 125 as an application under 25(2), as there being change in circumstance, but which would not be applicable to the present case since it's a consent decree. If I may, my lord, the consent decree has not been challenged in accordance with law by the wife.
I'd learned counsel for the petitioner. Issue notice to the respondent. Pending consideration of IA for delay, IA2 for stay is taken up. There shall be stay of operation and execution of the impugned order dated 6/12/24 in criminal miscellaneous number 543 of 23 on the file of First Additional Principal Judge, Family Court at Mysore till next date of hearing. Yes, Mr. Rohan and Kapil. Why is this matter listed today?
Your Lordship's order on 21st of March was for production of the child before the Registrar Judicial so that custody could be handed over by the respondent to the mother, by the mother to the father, who's the petitioner, for 50% of the court vacations. At 11 o'clock, I was present with my mother, the child's grandmother, before the registrar.
What happened? Yes, what happened?
She has not come. Her phone is switched off. We tried reaching out to her brother. Her brother claims he's unsure or unaware of where he is. Even, unfortunately, I'm constrained to say party's counsel is unaware of the respondent's whereabouts.
Yes, Mr. Kapil, what happened?
My lord, we had conveyed the order of this honorable court. However, my lord, the last instruction I received was that the party is exploring her legal options of review and appeal, my lord. She intends to go on an appeal on this order, my lord.
That is your inherent fundamental right. You can go.
Yes, my lord.
Nobody is stopping you.
Yes, my lord.
Where is the compliance of this order?
Your Lordship, from what I'm informed, yesterday the registrar has made a recording of the proceedings before her, stating that may be on the court's file. I've not been provided a copy.
Yeah. So direction was to bring the child Swadha Sahai to court premises on 7/4.
Yes, Your Lordship.
Yesterday.
Yes, Your Lordship.
Keep the child present before Registrar Judicial 11 a.m.
Yes, Your Lordship.
Yes. So she was not brought.
My lord, I was present, my lord. However, the party could not be present, my lord.
All right. So what is your instructions?
My instruction is that she intends to explore her options, my lord, on appeal. That is only last instruction that I've received, my lord.
Where is she? Where is the child?
I'm not aware, my lord.
You're not aware or you don't want to tell?
I'm not aware, my lord. Even I tried reaching out to her. Unfortunately, I'm not able.
I'll record your statement that the counsel is not aware about the whereabouts of your client. I'll record it. I'll proceed further with the matter.
In fact, Your Lordship,
this is what you think your tactics are going to be of your client. And if you are hand in glove, you will take action on that. This court, you should understand and keep in mind, this court is parent patricia jurisdiction in a child custody matter.
Yes, ma'am.
And I've been watching this from the beginning. The attitude and behavior of your client.
Yes, ma'am.
And I've told time and again that I don't know what is going to become the mental status of the child because of the attitude of your client, because of the ego which he's carrying. You are going to cause a lot of trouble to the child. I expressed this. If you don't understand it, I'm sorry. You are not obeying the orders of the court, whether she is in Bangalore or outside.
I'm not aware, my lord.
All right, I will direct the police commissioner to trace her out.
Yes, Your Lordship. In fact, in a similar situation, this court
Where is
has
that,
issued
where is the residence of that lady?
Electronic City, Your Lordship.
Give their address.
I'll give the full address. And in fact, I'll just place on record for Your Lordship's consideration.
Any judgment?
Yes, sir. Exactly similar circumstances.
Even without that, I will pass orders.
Very. Court has issued direction to issue a warrant for production of the child and the mother, and a direction to the police to assist in ensuring the child's produced.
Yes, you want to rely on something?
My lord, I'd like to file a memo, my lord.
Of what?
stating that the respondent would like to exercise her right to appeal.
Yes, I will. That is anyway available to you. I'll permit you also.
Much of
Please go and challenge it.
Yes,
You don't need a permission from the court. It's your right, inherent right to challenge the order of this court.
Yes, ma'am. That's my
Until you get
submission,
that reversed.
Yes,
This order will stay.
yes.
So as of now, you are already in contempt. Yes, which paragraph?
Yes, Your Lordship. The paragraph in Justice Veerappa's judgment is at paragraph 13. On the third page.
Yes.
Order sheet of this court.
Huh?
I'll read
Paragraph
brief.
number 13.
13, Your Lordship.
Order sheet of this court, yes.
Yes.
Hmm.
Thereafter, this court by an order dated so-and-so directed the learned counsel for petitioners to keep the minor child present before the court on 19/6/2014. On that date, the children were not present and hence the case was adjourned to so-and-so. On 26/14, also there was no representation on behalf of the petitioners. Therefore, this court observed that the petitioners have no respect or regard for the court orders. This court ordered the issuance of non-bailable warrants to petitioner number 1 and 2, with whom the minor child was staying, through Superintendent of Police Dharwad, returnable on such and such date. Since NBW returned unexecuted on 30/6/2014, this court directed reissuance of NBW to petitioners 1 and 2 and also to bring the minor children. Again, the matter was posted on 4/7. On that date, Sub-Inspector DSA Unit, Office of Superintendent of Police Dharwad, filed a detailed affidavit with regard to efforts made by them to arrest petitioners number 1 and 2. From the affidavit, it is clear that the petitioners are evading process of law and they have scant regard for the court orders. The learned counsel for the petitioners is of no assistance to give effect to the orders of this court. In fact, it appears that every order passed by this court is communicated only to frustrate the orders. In these circumstances, it is appropriate to issue non-bailable warrants to the petitioners except petition number 1, who is under treatment. Therefore, this court is directed to reissue non-bailable warrant to petitioners 2 to 7 through Superintendent of Police Dharwad, returnable on 10/7/14. The police were directed to produce the minor children, that is so-and-so and so-and-so, before this honorable court immediately after they were traced. The Commissioner of Police Mumbai was also directed to give necessary assistance to Dharwad Police to execute the NBW. It is also observed that the said order to give effect that the conduct of the petitioners and their counsel is unacceptable and appropriate proceedings will be initiated after the children are produced. Again, when the matter was posted on so-and-so, on that date, both petitioners number 1 and 2 and the minor children were present before the court. Therefore, this court passed an order to the effect that in terms of the order dated so-and-so, the minor children will be handed over to the custody of Srimati so-and-so, who is the mother of the minor children, in that case, the respondent. The police inspector Dharwad Rural Circle was directed to give protection to the mother and the minor children till they reach their home safely. This is what happened at the interim stage in that petition. Eventually, custody was transferred to the respondent who had been granted interim custody by the trial court, which had been challenged before this honorable court by the grandparents of the children, in that case, who were the petitioners. So the grandparents in that case were withholding grant of access, were disobeying orders of this honorable court. This honorable court stepped in and said, our orders cannot be trifled with. We will issue warrants for production of the parties concerned, and went ahead and did that. Now, in this case, Your Lordship, there are two concerns. We have a very strong apprehension that given the fact that the respondent and her brother, who though not a party to the petition, is the person with whom she is residing, are people of significant means, and he has significant business interests and clientele in America, that there may be a very good chance that she may be trying to evade the process of court, not only by not complying with these honorable court's orders, but by taking the child abroad. To that extent, if Your Lordship will indulge me, apart from issuing a warrant for the production of the respondent, whether it be a bailable, non-bailable, I leave it to Your Lordship's discretion. There can also be an instruction issued that the regional passport office provide information to this honorable court as to whether any application for the minor's passport has been made. And if so, directions be issued for information in relation to that application be provided to this honorable court.
Because you should know whether there is a passport issued in favor of
Your Lordship, we have in fact written to the regional passport office. I've already produced a copy of that communication with my petition. We have not received a response to that. We are only concerned about three things. Number one, we don't know where the child is right now. Even the council doesn't know where the child is right now. Number two, when we spoke to the mama, the respondent's brother, he feigned ignorance. Number three, when we try to obtain information from the school as to where the child might be, the school also says we don't have any direction to give any information. So we are concerned, number one, that she may have moved out of this honorable court's jurisdiction, or she may be hiding within this court's jurisdiction but without informing us. Number two, she may have applied for and obtained transfer certificate to remove the child from the admission that or the roles of the school that she's currently in. And number three, she may be making some effort to take the child outside the country, because in these circumstances with people who have means, they may do these things. We have seen this happen in the past. So that is my apprehension. I leave it to your lordship's discretion to decide what remedy to use. But I would think, your lordship, at least at the bare minimum, a non-bailable warrant or a bailable warrant be issued for her production, at least for the Commissioner of Police to take the assistance of the Electronic City Police to get her to come before your lordship.
However, my lord, the child, as per my knowledge, my lord, the child doesn't have a passport, my lord. The request that was placed before the petitioner father to apply for a passport was rejected by the petitioner father a couple of years back, my lord. So therefore, as per my knowledge, the child doesn't have a passport.
And it makes it easier. She will be here then. Let her come.
What's the difficulty? The child, according to you, is not taken out of the jurisdiction of Bangalore, Karnataka, or India.
Regarding the passport, I am aware of that, my lord. But the rest of the things, my lord, even I have not received any instructions as such, my lord.
So you will keep your client present, the child present, even if the client is not required. You will keep the child present at 2:30, or you want me to pass coercive orders?
My lord, I'll kindly pass over the matter. I'll again try to reach out to the client and
keep her present along with the child, because we have directed, this court passed an order that you will hand over and you will be present before the registrar. In fact, the respondent is directed to bring the child, not only the child, to the court. So there is a direction even to the respondent to bring the child present before the registrar judicial yesterday.
Yes, ma'am.
So you keep your client and the child present at 2:30, otherwise you will face consequences.
Yes, ma'am.
Please inform this to your client. You are at liberty to challenge the order.
Yes.
And if your client thinks she is very smart and intelligent, this court knows to deal with your client. Yes.
I'm obliged.
Much obliged. Call this matter at 2:30. First matter.
For petitioner, my lord, in this case, my lord, the respondents, being a grandparent, my lord, have filed a Section 9 application seeking custody of their grandchild, my lord, grandchildren, before the family court at Hassan. But in their pleadings, my lord, they admitted that the children were studying and they are in the custody of their father.
Who has filed this IA 1 for 25?
It is filed by the petitioner, my lord, the father.
For early hearing.
Yes, early hearing, my lord. The thing is, my lord, I'm insisting for interim order, my lord. Though the petition filed by the grandparent,
Order
my lord,
sheet. You are served. You are appearing for one and.
Well, as I'm a proxy counsel, I appear on behalf of advocate for respondent number 1 and 2, my lords. There is some personal inconvenience to the council.
my lord, the thing is,
I've
my
been
lord,
requested to take an adjournment for 1 week, my lords.
the thing
There is
my
some
lord,
personal inconvenience.
it may consider by interim prayer, my lord, because though the petition is not maintainable before the family court of Hassan, my lord, the family court of Hassan, my lord, they continued the proceedings, my lord, every week, my lord. My lord, may kindly see. May I point out, my lord?
You are seeking for quashing of the order dated 14/10/24.
Yes, my lord, where I filed an application challenging the territorial jurisdiction over the petition, my lord, before the family court at Hassan, my lord. Because kindly see, my lord, Section 9, my lord, I extracted in my grounds, my lord.
What is the order passed by this court?
Order passed by this court, my lord, the application filed by me challenging the territorial jurisdiction over the petition, my lord, is dismissed, saying that it's a tribal issue, my lord. It's a tribal issue. May I read, my lord? And impute order, my lord.
1 minute.
Annexure L, my lord. Annexure L. Para number 7, my lord. Annexure L, para number 7, my lord. Reasons.
My lords, my humble request, my lords.
My lord,
It may be heard an interim order.
Let them not precipitate the issue before the family court of Mysore, my lord. I filed
Yes, what is it that you're challenging?
I challenge the annexure L, my lord, where
Page.
at page, my lord, annexure L, my lord. I think page is not good, my lord. Annexure L. 32, 33.
Yes, page 43.
43, my lord.
A3 filed by respondent under
Kindly come to
section
para
9.
number 7, my lord. The reasons, my lord.
CPC is dismissed.
There is no dispute regarding the relationship between the parties. Late Anupama M.R.
ಎಲ್ಲಿ ಓದ್ತಾ
Bani,
ಇದ್ದೀರಿ?
para number 7 of the impugned order, my lord. The reasons, my lord.
Who are you in this case?
I am the father, my lord. I am
Father.
respondent in the petition, my lord.
Who is the respondent?
I am the father of the children, my lord.
You are the respondent, father.
Respondent father.
Petitioner yaru?
Petitioner hearing. Petitioner grandparents, my lord.
What happened to the mother?
Mother died, my lord. After, my lord, when they are in trip to Goa, my lord, while they are taking lunch in the hotel, my lord, she suddenly collapsed due to low BP, my lord. She died. Thereafter, the children are in the custody of the father and they admitted to school in Srirangpatnam, Mandya, my lord. Though they are admitted to school, they are studying in Srirangpatnam, Mandya, my lord. The petition is filed in Hassan, my lord, by the grandparents.
Maternal grandparents.
Paternal grandparents. No, maternal grandparents.
Maternal.
Sorry, my lord, sorry. Kindly see the, I put it there.
So the children were, two of them?
Two of them, yes, my lord.
They were with you after the mother died?
Yes, my lord.
So you are residing where?
I am residing in Nagunalli, Srirangpatnam, Mandya district, my lord. It is my permanent address, my lord. I am working at Bangalore. Kindly see the document put it by me, my lord. Annexure B, my lord. Annexure B and C. These are the school certificate, my lord, school ID card of the year 2024-25, where the elder daughter admitted to UKG, the another younger daughter, son, my lord, admitted to pre-KG. At next page, the school receipts that I paid for the year 2024-25, and also produced an Aadhaar card showing the address of the Mandya district, my lord. Annexure F, page number 22 and 23. Can you see the address in the Aadhaar card, my lord?
Hassan is the address.
No, not Hassan, my lord. It's in Srirangpatnam, my lord. Annexure F, page number 22. Aadhaar card. Charvi Gopal, son of Gopal so and so, Melapura, Srirangapatna, Mandya, Karnataka.
Annexure?
Annexure F, page number 22.
Of the petition?
Of the petition, my lord. Yes. Before that, my lord, annexure B and C are the school ID card. Mandya.
All right.
Aadhaar card, my lord. Annexure B, my lord, kindly see the school ID card issued by the school at St. Francis School, Nagunalli Gate, Srirangapatna. Annexure B, page number 16. Annexure C, kindly see, my lord, is another child ID card, my lord. It's of the admission to pre-KG. Next is, my lord, the school fee paid. Annexure D, my lord, page number 20, where I paid a school fee for the year 2024-25 for Charvi Gopal, that one son, one daughter, and Keshav Gopal, 21, my lord, school fee paid for the pre-KG. Annexure F and F is the F and G are the Aadhaar card, my lord, showing the address of the Nagunalli Srirangapatna Taluk, my lord.
That is in 2024.
No, 24, yes, my lord.
All right. So
it has not been disputed, my lord. Can you see the objections filed by them, my lord? Objections filed to the application, my lord. At Annexure J, my lord. Taped copy, my lord. I will read the Annexure J, my lord. Para number 2, my lord. ರೆಸ್ಪಾಂಡೆಂಟರು ತಮ್ಮ ಮಧ್ಯಕಾಲೀನ ಅರ್ಜಿ ಮತ್ತು ಪ್ರಮಾಣ ಪತ್ರಿಕೆಯಲ್ಲಿ ಸುಳ್ಳು ಅಂಶಗಳನ್ನು ಸೃಷ್ಟಿಸಿಕೊಂಡು ಮಧ್ಯಕಾಲೀನ ಅರ್ಜಿಯನ್ನು ತಂದಿದ್ದು ವಜಾ ಆಗಬೇಕಾಗುತ್ತದೆ. ಅರ್ಜಿದಾರರು ತಮ್ಮ ಅರ್ಜಿಯಲ್ಲಿ ಹೇಳಿರುವಂತೆ ತಮ್ಮ ಮಗಳ ಮೈನರ್ ಮಕ್ಕಳಾದ ಚಾರ್ವಿ ಮತ್ತು ಕೇಶವ್ ಗೋಪಾಲ್ ರವರುಗಳು 2023ನೇ ಸಾಲಿನಲ್ಲಿ ಹಾಸನದಲ್ಲಿಯೇ ವ್ಯಾಸಂಗ ಮಾಡುತ್ತಿದ್ದು, ಅಂದ್ರೆ 2023 ಬಿಫೋರ್ ದಿ ಡೆತ್ ಆಫ್ ದೇರ್ ಮದರ್ ಮಾಡುತ್ತಿದ್ದು, ಈ ಬಗ್ಗೆ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ದಾಖಲಾತಿಗಳನ್ನು ಹಾಜರುಪಡಿಸುತ್ತಾರೆ. ರೆಸ್ಪಾಂಡೆಂಟರು ಮಧ್ಯಕಾಲೀನ ಅರ್ಜಿಯ ಪ್ರಮಾಣ ಪತ್ರಿಕೆಯಲ್ಲಿ ವಿಳಾಸವನ್ನು ಮುಚ್ಚಲ್ಪಟ್ಟಿರುವುದು ಅವರು ತಾವು ಸಲ್ಲಿಸಿರುವ ಜೆರಾಕ್ಸ್ ಪ್ರತಿಯ ಆಧಾರ್ ವಿಳಾಸದಲ್ಲಿ ವಾಸವಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಹಾಲಿ ಪ್ರಸ್ತುತ ಇರುವ ವಿಳಾಸವನ್ನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮುಟ್ಟಿದ್ದು ಮಧ್ಯಕಾಲೀನ ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ರೆಸ್ಪಾಂಡೆಂಟರು ಪ್ರಸ್ತುತ ಕೇಂದ್ರ ಸರ್ಕಾರ ಸ್ವಾಮ್ಯದಲ್ಲಿ ಅಧೀನಕ್ಕೊಳಪಟ್ಟಿರುವ BL ಸೋಂಟಲ್ಲಿ ಮ್ಯಾನೇಜರ್ ಆಗಿ ವಾಸ ಮಾಡ್ತಿದ್ದು ಅವರು ಸದರಿ ಕಂಪನಿಯ ನೀಡಿರುವ ವಸತಿಗೃಹದಲ್ಲಿ ವಾಸವಿರುತ್ತಾರೆ. ಈ ವಿಚಾರವನ್ನು ಮಾನ್ಯ ಗೃಹ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಮರೆಮಾಚಿ ಮದೆ ಸೋಂಟು. The admit, my lord, my plainly see, I relying on the judgment of the honorable court, my lord, it is clearly applicable to this case, my lord, where also a application is made by the mother, my lord. Plainly see, my lord.
What is the order you're challenging now?
I am challenging the dismissal of the application filed by me, challenging the jurisdiction of the family court at Hassan, my lord. Annexure L, my lord.
So the petition filed by the parents of your wife.
No parents, my lord. Petition filed by the parents of wife.
So that you challenge that it does not have jurisdiction.
Yes, my lord.
That is IA number 3.
IA number 3, my lord. Yes.
So that is rejected.
That is rejected. For the reason that, my lord, the jurisdiction is a tribal issue.
Oh.
May I read the judgment, my lord?
Huh?
Really applicable to this case.
There is a lawyer to controvert you. Where is his counsel? He is not here. What is the great urgency here?
Urgency is, my lord, I want stay of the proceedings before the trial court, my lord. Because
Because it may be heard on merits the next week any day.
Going on, my lord.
Huh?
The proceedings are going before the family court, my lord, every week, my lord. Let there be a
What
stage.
is the stage?
Stage is, my lord, that admission stage, my lord. I filed objections.
What is the stage?
Trial is not yet commenced, my lord. Stage is, my lord, I filed objections to hear on IA, my lord, that's all.
How you filed application for early hearing?
My lord, the urgency is, my lord.
Now where is the provision for early hearing? What does the early hearing means?
My lord, I do agree, my lord. I do agree. But in view of the urgency, I filed the application.
In urgency there.
Allah, my lord, Kerala court, my lord, Prativara, they are going on, the proceedings is going on, my lord. I want to travel along with my child to the Hassan court every week, my lord.
Along with your child?
Yes, my lord, there is a order.
Children are with whom?
Children are with father. But there is an order by the trial court, my lord.
Children are with you?
Yes, with the father.
How the?
Yes,
I'm not aware, my lords. Proxy court.
Right,
that is their contention, my lord.
No, now the case that is filed is by the grandparents maternal of your wife.
Seeking custody of the children.
Correct. Children are with you.
Yes, my lord.
So you enjoy, we'll consider this later. What's the difficulty?
No, my lord, the thing is, my lord, in the meantime, my lord, there is an order by the family court by giving a visitation rights. That is, I don't have that copy, my lord. But there is an order.
Adhan challenge madidira?
That I have not challenged, my lord. Because its petition itself not maintainable, my lord. That's my contention. If this goes, my lord, everything will go, my lord. If this petition allowed, my lord, that everything will go, my lord.
So you go take the children and go and meet the. How old are the children?
How old are, my lord? They are only 6 years and 5 years, my lord.
So what is the visitation rights ordered?
Ordered, my lord. I need to take the children to the Hassan, my lord. In monthly once, I learn, madam. Monthly once, 15 days.
Monthly once.
Monthly once.
Saturday and Sunday. Na?
That I don't have clarity, my lord. I want to take instructions, my lord.
All right. So once in a month you have to take.
Month or twice, my lord.
Once in a month hogbekalva?
Month or twice, I don't have idea, my lord.
Adunu gottilla. So you have to go from Srirangapatna to Hassan.
Hassan.
What's the distance?
Distance is around 150 kilometers, my lord.
Okay, Thorsput Bunny, grandparents. Learned counsel for the petitioner is present. There is no representation. The learned counsel for the respondent seeks time. Counsel for the respondent seeks time on behalf of respondent. Call this matter on 17th.
Grateful.
ಮಕ್ಕಳು ನಿಮ್ಮ ಹತ್ರ ಇದ್ದಾರಲ್ವ?
ಇದೆ ನನ್ನ ಹತ್ರ ಇದ್ದಾರೆ.
Issue notice. Any dispensation? List number 2. Yes, issue notice. Serial number 37. Oh, okay. Now from that is transferred. Siddheshwara. ಏನಕ್ಕೆ ಪಾಸ್ವರ್ಡ್?
Election another quota.
ಎಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಬರೆದ್ರೆ ಇವಾಗ ಏನು ಕೂತ್ಕೊಂಡು ಮಾಡೋದು ನಾವು? ಪಾಸ್ವರ್ಡ್.
Lord, list number 3, my lord.
Yes, list number 3, all matters are issue notice.
Once on submit, list number 3, issue notice. Lord, list number 3 is for referring the matter to Lok Adalat.
Lok Adalat all referred.
Allah, idರಲ್ಲಿ some of the matters are filed by the company.
ನೀವು ಯಾರು ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು ನಾವು? ಯಾವ್ದು ಹೇಳಿ?
Lord, serial number 5, my lord.
ಆಗಲ್ವಾ?
ಇಲ್ಲ ಆಗಲ್ಲ. Company matter.
Serial number 5. Next.
Then my lord, serial number 20.
Serial number 20.
Please, my lord. That's all. That's all.
All right. Serial number 5 and 20. List this matter after 2 weeks.
Please, my lord.
Yes.
For respondent in this case, Lord, party presented a ಕೇಳಿದ್ದು last time ಬಂದಿದ್ದಾರೆ party, but ಅವರು mutual consent ಗೆ they are not filing any case. As this court is ordered, we have paid 20,000 according to the court order, but ಅವರು mutual consent ಬಗ್ಗೆ ಏನು ಮಾತಾಡ್ತಾರೆ ಸ್ವಾಮಿ?
You are appearing for respondent?
Respondent, yes, my lord.
Your client is here?
My lord?
Client is present?
Yes, my lord. Achha, correct. One minute.
Where is the petitioner?
She is also there, but advocate is not here.
Advocate is not here.
I'll ask, shall I call them?
What was the proposal to, what was the proposal?
As they said initially, respondent having 6 houses to give one
You will
house.
transfer one house or rent
Yes,
of one house?
house and one for a maintenance. Either she
They
can
did
leave
not
there.
get back?
They are not any reply from that side, and they are not filed a mutual consent divorce petition also.
So only if he agrees to those terms, you will file, na?
No, they have to file, my lord, because you're give a direction to them to file a mutual consent. In the previous order itself, the petitioner
Consent
is
means
agreed.
both have to file.
Yes, my lord. If they are not said, we only file it.
We'll see if he comes. Noted, whether he.
Last time also he didn't come, and 1:30 he took a date, my lord.
No, now he's the, what is the, that order that is questioned here?
But, my lord,
What is the order that is questioned? Really, ma, court officer.
I didn't get. My lord, ಕೆಳಗಡೆ court ಅಲ್ಲಿ they are asked for maintenance, that petition is dismissed. No maintenance is awarded.
Yes.
Or kindly pass on.
My lord, this is the same thing. Last time also password ಕೇಳಿದ್ರು 1:30 ಇಲ್ಲಿ ಬಂದು sir ಅವ್ರದ್ದು senior ಬಂದು time ತಗೊಂಡು.
You have to discharge your duty. You are not
Lord,
responding.
what they did
And
is,
what they are doing is, they are showing some sets, and she is blaming. Her husband came before this honorable court as an advocate. He has undertaken before this court to pay monthly 20 rupees, which is not paid. And thereafterwards, your lordship directed to show the house, which they have shown some sheds, which is not done. Therefore, my respectful submission is, let them file affidavit before this honorable court, which property which they are giving, because they are not cooperating. Therefore, let them file affidavit, which property accordingly we will agree.
Last time property yavudanta?
Please, my lord.
Last time only she disclosed which property. One is either she will give the property in your name till your,
Therefore,
till your lifetime.
Not lifetime, that they have undertaken before this court, last date of hearing, kindly see the order sheet. That they have said they are going to register one property in my name.
Register ಅಂತ ಹೇಳಿಲ್ಲ.
ಅಲ್ಲಿ ನೋಡಿ ಅಲ್ಲಿ order sheet may kindly be seen. He has undertaken. They are going to register one property, that is house.
Apart from that,
yes, my lord. And that is advocate who is appearing has made a submission before this, your lordship recorded. And kindly see the house which they are, my lord, having. Let them come before this honorable court with the true fact that when they are going to register, and that 20,000 also 120,000 rupees has been paid. Remaining 20,000.
Where is your client?
Client is there.
She is sitting there in the corner.
Correct.
ಇಬ್ಬರು ಇದಾರಲ್ಲ ಇವಾಗ?
ಇದ್ದಾರೆ ಸ್ವಾಮಿ, ಇಬ್ರು
ಮಾತಾಡ್ಬಿಡಿ.
ಅದೇ correct.
My lord, one request
Sorry, I
before
was held
the
up
court.
in other court, therefore I was sorry.
My lord, one request before this court. As they said in their own petition in page number 8, they said this is what 6 houses are there. One house kodi ant kelidru. We are ready to give 2 houses, one registered till our lifetime, till our get a
Till our lifetime, bada
We are ready for that.
no,
No
whatever
issues are
whatever
there.
they have undertaken, 20,000 rupees.
No issues.
No issues, my lord.
My lord, adopted daughter ಇದೆ, ಮದುವೆ ಆಗಿದೆ.
That adoption is only
One second.
mother.
And
Sorry.
without divorce, he has got married. And my lord, there are other properties which stands. Kindly see these photographs she has taken. And my lord, this is all the house. And they are playing game with her life. And they have taken a contention before the court earlier, saying that she has got huge properties. When we have filed affidavit, they are avoiding and come before this honorable court. One property register ಮಾಡ್ತೀನಿ 20,000 ಕೊಡ್ತೀನಿ ಅಂತಂದ್ರು. Now once again they are changing. Therefore, my lord, let them kindly see the photographs. How many properties they have?
Shall I
ಇಲ್ಲ
submit,
ಇದ್ದಾರೆ.
my lord?
ಬನ್ನಿ ಅಮ್ಮ ಹೇಳಿ ನಿಮ್ಮ ಪರಿಸ್ಥಿತಿ ಸಾಹೇಬ್ರಿಗೆ.
ಅವ್ರ ಪರಿಸ್ಥಿತಿ ನೀವೇನಕ್ಕೆ ಇಟ್ಟಿದಾರ ಮತ್ತೆ?
Please, my lord.
You are the counsel. I am not going to hear.
Allah. Because she is ready to, if they are going to register property and paying 20,000, she is always ready. If photographs could be, this is all house stands in her husband name.
How many are there? How many houses?
Both kindly ನೋಡಿ ಒಂದು 20 ಮನೆ ಇದೆ. ಫೋಟೋಗ್ರಾಫ್ಸ್ ಅವರೇ ತೆಕ್ಕೊಂಬಂದು ಕೊಟ್ಟಿರೋದು ನನಗೆ.
ಇದರಲ್ಲಿ ಯಾವ್ದಿದೆ ಮನೆ?
ಅದರಲ್ಲಿ this is all he has rented. ಒಂದಲ್ಲ ಶೆಡ್ ಟೈಪ್ ಇದೆ ನೋಡಿ ಸರ್. ಆ ಶೆಡ್ ಮೂರು ಬಿಲ್ಡಿಂಗ್ ಇದೆಯಾ?
So petition is filed for what?
Petition is filed for maintenance and shelter, my lord.
Lower court maintenance petition is
Yes.
dismissed, my lord. It's not.
Dismissed only, not filing the affidavit.
request-
That delay has been condoned. And now after undertaking before this court, my lord, my learned counsel saying that, my lord, that she is not willing to pay anything, and
No, my
I have to regularize her his second marriage without divorce.
My lord,
All
one
these conditions
submission
that he
before
is
this
putting.
court, my learned senior counsel is submitting like that. She is also second marriage. She hide that marriage. Actually, trial court evidence agilla, cross examination agilla. This is her second marriage. She hide this first marriage and did the second marriage.
Let her file affidavit before
Yes,
this
yes.
honorable court.
We'll do it. But one submission, my lord.
Every time
At the
she will
same
come
time,
with a new plea.
my lord,
They have not
because
taken any
ಕೆಳಗಡೆ
contention.
court ಅಲ್ಲಿ it is not a fully fledged trial. It's dismissed. Evidence ಆಗಿಲ್ಲ ಕೆಳಗಡೆ court ಅಲ್ಲಿ. ಇಲ್ಲಿ ಬಂದಿದ್ದಾರೆ 30,000 ಕೊಡಿ
Undertake
ಅಂತ.
ಮಾಡಿದ complaint ಮಾಡ್ತೀನಿ.
Lord, I'll read out the order itself, the previous. Petition is agreed to file the petition for divorce under a mutual consent petition with the condition that our respondent husband register house. We are ready for that. But where is the mutual consent petition? Last time ಹಿಂಗೆ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅವ್ರು ಹೇಳಿದ್ರು 5 ಲಕ್ಷದವರೆಗೂ ದುಡ್ಡು ತಗೊಂಡೋದ್ರು.
ಕೊಟ್ಟರೆ ನಾಳೆ I am ready. I'll give draft.
No,
Let
my
her
lord.
give properties.
Let them
And
first
my
file
lord,
it.
property details ಕೊಡ್ಲಿ, ಈ ಖಾತಾ ಕೊಡ್ಲಿ, ನಾನು ನಾಳೆ ರಿಜಿಸ್ಟ್ರೇಷನ್
My lord.
ಮಾಡಿ ಕಾಂಪ್ರಮೈಸ್ ಪೆಟಿಷನ್ ನಾನು ಹಾಕ್ತೀನಿ, 20,000 ರೂಪಾಯಿ ತಾವು
What is your requirement?
Please, my lord.
What is your requirement? What she wants?
My requirement is, my lord, that we have got about 10,000 rupees per 3-4 disease ಇದೆ ಅವರಿಗೆ. The lungs disease ಇದೆ. There are other diseases like the diabetes and other disease. And my lord, therefore 10,000 which they have agreed earlier, which they have not paid, and she is alone. Now daughter is adopted daughter that she has got married to the husband, she is staying with them. And my lord, he has thrown out her, and all along, my lord, she is staying with parents. But they are also, my lord, is a coolies. And she has no other way. And father, out of coolie amount, he has given a site in Bangalore, which he has sold and enjoyed. Now, let them give details, and 20,000 monthly ಕೊಟ್ಕೊಂಡು ಹೋಗ್ಲಿ, ತೊಂದರೆ ಇಲ್ಲ. ನಾವು ready, we are compromised 13B ಹಾಕಕ್ಕೂ ready ಇದ್ದೀವಿ.
My lord, one
She never
submission.
says no. ಅವ್ರು ದಿನ ಒಂದು ಕಂಡೀಷನ್ ಬರುತ್ತೆ.
ಅವ್ರು ಹೇಳಲಿ.
Lord, we are not denied to give her anything. As only they said, their own petition ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ 6 ಮನೆಗಳಿದೆ 10,000 ಬರ್ತದೆ ಅದನ್ನ ಕೊಡಿ ಅಂತ ಅವರೇ ಕೇಳಿದ್ರು. We are ready for that, and also we are ready for one more house to give her. Let her take a maintenance and one more registration.
So you will transfer one house in the name of the.
Yes, for till her lifetime, because no issues are there. Issues ಇಲ್ಲ, my lord.
Issues daughter ಇದ್ದಾರೆ.
No, that adopted daughter is not his daughter.
daughter ಇದ್ದಾರೆ.
No, my lord.
Adopted daughter
Who
ಇದ್ದಾರೆ.
was adopted?
Yes, my lord.
Who was adopted?
Both of them they have
No, my lord.
adopted.
No, he's here only, please.
Let his file affidavit before this court. Daughter also will come, and let him file affidavit that there is no daughter which they have adopted.
My lord, one
Affidavit
submission.
ಹಾಕ್ಬಿಡ್ಲಿ ತೊಂದ್ರೆ ಇಲ್ಲ.
How old is the daughter?
She is ಎಷ್ಟು ವಯಸ್ಸು?
ಅವ್ರಿಗೆ ಮದುವೆ ಆಗಿದೆ ಸ್ವಾಮಿ.
30 ವರ್ಷ ಆಗಿದೆ. ಮದುವೆ ಆಗಿದೆ.
Whether it is by way of a registered adoption deed.
No, my lord.
ಇವರೇ ತಂದೆ ಅಂತಾನೆ ತಂದೆ ತಾಯಿ
ಎಷ್ಟು ವರ್ಷದಿಂದ ಮಾಡಿ? How many years back?
ಎಷ್ಟು ವರ್ಷದ ಹಿಂದೆ ಅದು? ಚಿಕ್ಕ ಪಾಪು ಇದ್ದಾಗಲೇ ತಗೊಂಡಿದ್ದೆ.
It is not official, my lord. Our the relation magu ante. No, my lord. 1 minute, my lord. One day one submission before, my lord. There is no officially adopted. Our relation magu ante karkondu ಓದ್ಸಕ್ಕೆ ಇಟ್ಕೊಂಡಿದ್ದು, that is true. Later on that when he knows that she had the first marriage, after that the jagla start ಆಯ್ತು.
ಆ ಮಗು ಎಷ್ಟು ವಯಸ್ಸಿಗೆ ತಗೊಂಬಂದಿರಿ ನೀವು adoption?
ಎಷ್ಟು ವಯಸ್ಸಿತ್ತು ಮಗು ಬಂದಾಗ?
ಕರೀರಿ ಅವ್ರ ಮುಂದೆ ಕರೀರಿ.
4 ವರ್ಷ ಆಯ್ತಂತೆ.
ಬನ್ರಿ.
ಬನ್ನಿ.
ಏನ್ ನಿಮ್ಮ ಹೆಸರೇನು? ಏನ್ ಕೆಲಸ ಮಾಡ್ತೀರಾ? ಎಲ್ಲಿ?
My lords, court is not audible, my lords.
Court is not audible, my lord. Court proceedings are hanged. Court proceedings are hanged. Court proceedings are hanged. Not able to hear anything.
My lords, court is not audible, my lords. My lords. My lord. Court is not audible and also muted. ಏನೋಗಪ್ಪ ಈಗ ಇವ್ರು ಹೆಂಗೋ ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ ಹೋಗೋದು ಒಳ್ಳೇದಂತ
ಹಂಗ್ ಮಾಡ್ಬೇಡಿ ನೀವು
ಮತ್ ನೋಡಿ
ಇವಾಗ ಟೈಮ್ ಊಟ ಟೈಮ್ ಹತ್ರ ಬಂತು ಎಲ್ಲ ಊಟಕ್ಕೆ ಹೋಗ್ಬಿಡ್ತಾರೆ ನೀವು ಅವ್ರು ಇದೇ ಟೈಮ್ ಎಲ್ಲ
ಮೈ ಲಾರ್ಡ್ ಮಾತಾಡಿ My lord, court officer. ಗಂಗಮ್ಮ ಕೋರ್ಟ್ ಅಲ್ಲಿ 34 ಲೈನ್ ನಡೀತಾ ಇದೆ ನೋಡಿ. ಹಾ, ಯಾವ ಕೋರ್ಟ್ ಅದು, ಏನ್ ಕತೆ? ಇಲ್ಲ, ಎದ್ದೋಗಿಲ್ಲ, ಹೆಂಗಾಗಿದೆ?
In this case, only for petitioner number 2. That is the daughter.
Daughter, my lord.
Hmm.
My lordship, in MC order, page 11.
So where is the order passed in the DV case? You have a copy of that order?
Yes, my lord. In the memo that I have filed,
Yes. Which is that order?
my lordship, page number 19.
19?
Yes, my lord. There also they have we have produced MC order and
19?
yes, my lord, in page 19.
Mama, you should say 2 different memos you file. You don't know. There is no such order here.
My lordship, in the assets
19 Allama.
19.
That is page number
19.
17. Orders on IA filed under 23(2) the DV Act. So what is ordered here? 10,000.
Yes, my lord. That after consideration of all MC order and CMS order, she has awarded this 10,000.
What about the education expenses?
My lordship, educational expenses is around 7,000, my lord.
Are you paying that?
No, my lord. I've not yet paid any of this because of 3 different orders. I have house loan. I'm also suffering from diabetes 1. Medical expenses. I've produced that also in my assets.
Out of all these maintenance orders, you have not paid even a single one.
Not yet, my lord. Because there are 3 different orders, and after deducting everything, I'll have only 20,000 left with me. MC is under review.
Case, the maintenance is ordered for the child.
In this 650.
So in the other 2 cases, it's not ordered.
My lordship, MC case, it's under review. They had filed. It was.
Now
Please.
you are before this court.
Please,
in
my
this
lord.
maintenance application.
Please, my lord.
Which is awarded to the child.
Child, yes,
10,000 rupees.
Yes, my lord.
In which other case the maintenance is awarded to the child? No other case. Though in MC case some amount is awarded.
Not all.
And in the DV case, it is not awarded for the child.
It is after considering all the expenses they've awarded to the mother, because the child is with the mother. Till date, child is not been shown to us because I'm staying in.
Challenge that other 2 orders.
My lordship, MC, it's under review. They have filed for review in MC court.
What have you done? They have filed reviews asking for enhancement. What you have done? And why I should stay this order? This is ordered for the child. Pay for the child. Are you paying the education expenses of the child?
It's not the fact that I'm not ready to. I'm willing to pay, my lord.
How much you are going
but
to?
It's so much amount.
How much you are going to pay?
From the date of the order, I'm ready to pay 10,000, my lord. This same is order. Because every other thing they've asked for from the date of application. If it is calculated by that, it's around 12 lakhs, 5 lakhs, 8 lakhs.
No, that is, please don't mix up everything. Now here we are concerned with 10,000 rupees. All other cases, you go and challenge, you get it modified. You don't want to challenge any, you have not challenged any of the order except this.
My lordship, other DV, they're challenging, my lord. We are challenging it before
This
this.
is for the child.
My lordship,
Amount of 10,000 is not ordered anywhere in
my
any
lordship,
other
at
case.
least from the date of the order, I'm ready to.
Which subject?
Same
Which
as
law-
650.
Which law says that it should be from the date of the order? Which law says?
My lordship, time being until other cases maybe final orders is passed. Because my lord, adding total, it would be a huge sum for me to pay.
Child is 5 years.
6 years now, as of today.
Okay, you can reduce it to 5,000 here, but others you have to challenge, madam. Learned counsel for the petitioner. Issue notice to the respondent. Counsel for the petitioner is permitted to take out notice to the respondent by way of hand summons and other modes of communication, including service of notice to the counsel representing the respondent before the family court at Bengaluru. Initial history of operation and execution of the impugned order. On IE number 2 in criminal miscellaneous number 650 of 23 dated 30th December 2024. Subject to the condition, the petitioner pays a sum of rupees 5,000 per month to the respondent number 2. Petitioner shall pay this amount of 5,000 and all arrears at the rate of 5,000. The arrears shall be paid within a period of 2 months. Application is filed in 23. All right. It's made clear this order is restricted to only the petition herein. That is concerning to criminal miscellaneous number 650 of 23.
Please, ma'am.
My lords, the case is for the speedy disposal of the case because the petitioner and the respondent in this case has filed for the divorce based on the cruelty, and the petitioner has filed for the GNWC, the custody of the child, and for the restitution of conjugal rights. From the date of filing till now, the respondent is not at all appearing before the court, and she's not at all showing the child where, and she's not at all showing where she exactly is residing. She's keeping away the child from the petitioner, my lords.
So section 9 petition is filed by the husband.
Yes, my lords.
You are appearing for?
Husband, my lords.
Who was for what the wife has filed?
For the divorce petition, my lords, based on the cruelty.
Same court?
Before the same court, my lords.
And she is not appearing?
She's not at all appearing before the court, my lord. And the case was referred all
the
the
earliest petition filed. Which is the earlier petition?
for the restitution of conjugal right, my lords.
Which year?
In the year 2023,
What is the stage of the case now?
my lords.
What is the stage of the case in the family court?
Summons, my lords. Thereafter, all the three cases, GNWC and restitution case, and all the three cases were referred to the mediation center. Even mediation has been failed since she is not at all keeping her present before the mediation center also, my lords.
GNWC also is filed.
Yes, my lords.
Who was filed?
By the husband. She has left the respondent, I mean the petitioner house by taking a child.
What is your prayer?
My lords, to direct the family court.
Read your prayer.
It's me. To direct the principal family court in GNWC 407/2023 in facilitating the respondent to make her parent along with the child, and by allowing the petitioner to have visitation rights of the child by further directing the Honorable Trial Court to dispose of the matter at an earliest within 6 months.
Now, you have some visitation rights granted.
Not it, my lord. No visitation has been granted because she is not at all keeping her present before the court. Since no,
Is that GNWC petition filed?
my lords,
When is that GNWC?
2023, my lord.
Date helima. You restrict your prayer only for disposal expeditiously.
GNWC.
Heard, learned counsel for the petitioner. What is your name? You're on Wakalat?
Yes, my lords.
You filed Wakalat?
Yes, my lord.
What's your name?
Amreen. My senior had to appear because the VC got hanged out for that
You
reason.
filed Wakalat, na?
Yes, my lords.
Counsel so and so. Notice to respondent is dispensed as this court is not inclined to pass any adverse order against the respondent. Will stop. Learned counsel for the petitioner restricts her prayer for expeditious disposal of the matter. She waives off the other prayer made in the petition with regard other full stop. Petition is allowed. The learned judge of the family court is directed to dispose of GNWC number 40 of 23 expeditiously. Extract section 21B of the Hindu Marriage Act. This provision. This you are only seeking expeditious disposal in the GNWC case.
Even for the visitation right of the child, my lord.
That I am not going to pass. The family court shall dispose of the matter expeditiously and decide any interim applications filed for interim custody or visitation rights of the child expeditiously, not later than 30 days.
Much obliged, Your Honor.
Madam, that you have to separate interim application only 30 days. Otherwise, expeditious disposal of the main matter. Yes. Yes, what happened?
Claims are, parties are here.
Huh?
Serial number 37, parties are here.
30?
37, my lord. So
37 is not before me.
Yes, it was passed over. Sorry, we were not present. I was in the quotal number 10, my lord, I was there. My lord, parties, with regard to my lord, we have got negotiated.
We know these are all.
Yes, our Lord, the demand of the respondent is 25 lakh. Lord, my client is ready to pay, my lord, 3,50,000. There is a more difference between this amount and all. That is the reason we are going to argue on merits.
All right.
By next week. If next week
is agreeable, I
at
may
request of
submission,
learned
otherwise
counsel for both
argue on
parties.
merit by next week.
Next week?
Next week.
Yes, call next week at request of both parties.
Public.
Later. That's all other matters 2:30.
I seek indulgence.
Yes.
I'm sorry. No, serial number 51, I have moved the memo where the deposit is made before this court. I have not preferred an application. I'll prefer the application. Your lordship's request to have it on Wednesday. And for the respondent.
What have you done?
Pursuant to order of this court, they have deposited before the High Court registry. I have to file an application seeking permission to withdraw this.
My lords, I appear in serial number 51, my lords.
I will file the application.
You have any objection in him withdrawing?
My lords, an application be made, my lords. I'll not object, but
What is the amount you have deposited? What is the need for application? I'll permit him accept his oral request.
very well, my
Maintenance amount.
maintenance amount.
Yes,
Maintenance
dispute
amount.
ಇದೆಯಾ ನಿಮ್ಗೆ?
ಇಲ್ಲ, but my objection may be recorded. It may be consent ಅಂತ ಆಗೋದು record ಆಗೋದು ಬೇಡ ಅಂತ ಅಷ್ಟೇ.
You should fairly admit in these cases. What is
Very well, my lords. Then I'm sorry, my lords. It may be allowed, my lords.
this matter on
Wednesday.
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 That's 14ನೇ ತಾರೀಕು ಬೇಡ, 17. I'm sorry.
You can. When do you want?
17, my lords.
17th.
Please.
ಮೇಡಮ್ MFA ಲಿಸ್ಟ್ ಅದು ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿದೆಯಾ? MFA ಲಿಸ್ಟ್ ಇದೆಯಾ? ಎಲ್ಲವೂ
ಪಾಸ್ ಓವರ್ ಎಷ್ಟು ಪಾಸ್ ಓವರ್ ಎಷ್ಟಿದೆ ಪಾಸ್ ಓವರ್?
ನಾರ್ಮಲ್ ಆಯ್ತಾ? ನಾರ್ಮಲ್ ಏನ್ ಓದ್ತಿದ್ದಾರೆ ಇಬ್ರು ಮಗಳದಿರು? ನೀವು ಬಿಡಿ. The blue one. She didn't switch on the AC.
in the list which was the matters of which list were to be in the list which was the matters of which list were to be referred to the Lok Adalat. Serial number 15 and 16, they are pertaining to the liability issue, Your Lordship, so they may not be.
All right, 15 and 16 not referred.
And also my colleague brother Jwala Kumar was also submitting that serial number 8 is also pertaining to liability.
All right, serial number 8, 15 and 16.
Applies to.
Post after 2 weeks.
Applies to, Your Lordship.
Settlement ಆಗ್ತಾ ಇದೆಯಾ? You're appearing for whom? You're for petition. You agree? You left after 2 weeks? Huh? All right. Learned counsels for both parties submit that. Learned counsels for both parties submit that. Settlement talks are midway, hence they seek time to report settlement. Call on 16th April. Interim order, if an operation is extended till next date of hearing. Kalburgi bench, Subhash Mallapur, Sajjan Shetty, correction of the judgment. Correction. To the claimant, full stop, ordered accordingly. Yes. Yes, what happened, that 230 matter? So what happened, Mr. Kapil?
My lord, we are not able to contact the respondent, my lord. Therefore, my lord, as I submitted earlier, my lord, I may be allowed to file a memo stating that the respondent intend to file her appeal before the Supreme Court of India. So the memo may be taken on record, my lord. That's my humble submission.
Or application. You filed some application today?
I have an application. So my due to lordship is a formal application not required in the situation that there is. Before the scope of issue warrants. So lordship requires to have an application ready. It's just in the interest of time I thought.
All right. So you have relied only on the judgment.
I relied on one judgment to our high court. There is in the situation there is no reason to Supreme Court. So lordship requires that also available for the times.
Good. Please give it.
I've given the copy.
All right.
2021 forum after another.
All right. Good evening. Yes, you relied on this already.
Yes, the other one I also provided. I have another one.
What do you mean? Which is that other one?
2 pages. In the habeas corpus petition before the High Court, party has the right to consent on terms of settlement.
You're reading para?
Para 3.
Petitioners have submitted.
The directions were passed as a record in paragraph 2. And then they submit that one of the directions was that the father in that case was required to see the child at a particular location and only travel to Abu Dhabi, where the place of work was. The violation of the consent order passed in the High Court in the habeas corpus. The father took the child away to his home country of Egypt. Violation of the law. In relation to that, proceeding to initiate before the Supreme Court. Supreme Court says that the honors. Petitioners are submitted in terms of directions 7 above. The first respondent to grant the liberty to leave and get present the child from until then access to foreign communications will be. However, it has been alleged on 15 February an email was received from the respondent stating that he is taking the child to Egypt. The grievance to petitioner is that those first respondents required to bring the child to India until the duration again. 4 times a year. This duration has been reached. It is also been submitted the access and review corpus in such duration letter has not been provided. Though the petitioner has tried to contact the first respondent to the in paragraph 5, notice was issued in these proceedings on such and such date. Notice has been served. Mr. So-and-so entered referrals for the first respondent who will be every father in these proceedings. On 1st March, the case was dismissed was responded to that. On the request of the court, both Mr. Alu and Olivia Pandey contacted Mr. So-and-so to intervene with some parties left in the which, according to I understood, is not the case over here. So we need only a direction from your lordship. If there is a law not being important to issue for the execution to be commissioned with assistance of the electronic police officer.
Yes. You want to retort to anything what he said? Record. What is this? 21/3/2025 passed an order directing the respondent mother to keep the minor child Miss Swadha Sahai present before the court on to be present before the court on 7/4/2025. Present before the registrar judicial. Present before the registrar judicial on 7/4/2025 at 11 a.m. It appears that the child is not kept present on 7/4/2025 at 11 a.m. before the registrar judicial. Hence, the petitioner, father of the minor child, has moved this court to take up this matter as the respondent has not complied the order of this court, whereby this court had passed an order granting interim custody of the minor child. Where is the condition of handing over child to you from when? Page? No, no, operative portion it should be there. Page 26. 26. No, no, the vacation period was ordered to be given to you. Where is that? 1/3. 50% of the summer vacation starting from 6/4/2025 to 2/5/2025. Accordingly, to enforce such a custody and visitation rights of the father and the paternal grandparents of the minor child, the respondent was directed to bring the child and keep her present before the registrar judicial on 7/4/25 at 11 a.m. for the child to be handed over to the petitioner father and the grandparents. Full stop. The petitioner and his parents were present before the registrar judicial at 11 a.m. on 7/4/2025. Were present. However, the respondent and the minor child were not present. Hence, the custody of the minor child was not handed over to the petitioner. Full stop. Today, when the matter is taken up at the motion of the petitioner, learned counsel for respondent is present. There is no representation. The respondent is not present, so also the minor child. Learned counsel for the respondent submits that he has no information and instruction and information with regard to the whereabouts of the respondent. You don't know the whereabouts.
No, my lord.
He does not know the whereabouts of the respondent mother, so also the minor child. He also submits he is unable to get in touch and contact with the respondent, and he has no instructions. Full stop. At the same time, he files a memo seeking leave of this court to keep this order in abeyance as the respondent wants to challenge this order before the Honorable Apex Court. Who has given you these instructions?
My lord, I got the instruction from my office, my lord.
Which is your office?
My senior gave this instruction, my lord. Kapil Dikshit.
Who has given him instruction?
My lord, once we communicated the order to the respondent, this is the discussion that has happened, my lord.
When?
My lord, after 3rd of April, my lord.
Why you did not file it earlier? you got this instruction and who gave you the instruction?
My lord, however, we don't know where the respondent is on 7th.
That's precisely why I want to know who gave you these instructions to file this memo.
My lord, when the order was communicated, order dated 21/3/2025 was communicated. This was what was informed, my lord.
That you did not file in the registry by serving him a copy and saying that you will not bring the child, you are going to challenge this order. You did not say so, neither in the morning.
My lord, in the morning, I informed this honorable court that the respondent intends to challenge the order.
Right, that is anyway you're right, you can challenge, but
Yes,
who
ma'am.
gave you this instruction now? When
My
you
lord,
are
this
not
is
in touch with the respondent.
this is the memo that I intended to file in the morning, my lord, before the honorable court.
Learned counsel for the petitioner relies on a judgment of the Honorable Apex Court in the case of Olami Apte and another versus Khalid Kamal Hussain Muhammad Qasim and another reported in 2021 SEC Online, SE 3320, relying on paragraph number 3 and 5, wherein in similar circumstances, in a case of habeas corpus petition, the Honorable Apex Court ordered issuance of a bailable warrant against the respondent therein. Due to breach and violation of the order of the court reported in 2015 SEC Online Karnataka 9504, 2016 Volume 2 KCCR 1517. He relies upon paragraph number 13, where this court, the coordinated bench of this court, ordered issuance of a non-bailable warrant to the petitioners 1 and 2, with whom the minor children were staying, through the Superintendent of Police Dharwad, It is also submitted by learned counsel that in the said case, the Commissioner of Police Mumbai was also directed to give necessary assistance to the Dharwad Police to execute the non-bailable warrant to give effect to the orders passed by the court. Learned counsel seeks similar orders in this case. Full stop. Apparently, it is seen by the conduct of respondent that she has deliberately disobeyed with scant respect for the orders of this court. She is not present before the court along with the minor child as ordered by this court, which itself speaks volume about her conduct and the sanctity of the orders of this court that is disobeyed by the respondent. Full stop. However, this court is of the opinion that one more opportunity deserves to be given to the respondent to keep the child present before this court on 9th, tomorrow at 2:30 p.m. in view of the submission made by learned counsel for the respondent that the respondent intends to is available, there is no need of any permission that requires to be granted by this court. She is at liberty by the court. She will have to comply with the orders passed by this court. Therefore, this court directs the respondent to keep the minor child present before this court at 2:30 p.m. tomorrow, failing which precipitative coercive action would be taken against the respondent for disobedience of the orders of this court. List this matter tomorrow at 2:30. Yes, tomorrow 2:30. Yes. We'll pass further orders. You can be here tomorrow 2:30. ಅದರಲ್ಲಿ ಆಡ್ ಮಾಡ್ಕೋಬೇಕು ಅವರೆಲ್ಲ ಹೋಗಿದಾರಲ್ಲ, including issuance of bailable and non-bailable warrant against the respondent. Yes, gone. Or idre kariri, just call that gentleman, Mr. Kothari. Somebody can call that advocate if he's outside. Both. Just call your brother Kapil also, friend Kapil. Yes, Mr. Gaikwad.
We have already filed the arguments. We have been given only about within 1 month I have completed our arguments. He has taken 5 months time. The Supreme Court also directed on 16/2024 after 6 months duration. Within that itself we have completed all the formalities and he took around 5 months, 1 day is the time, 12 times we have taken time. But instead I gave a response. I have also concluded my argument by saying that the application of two documents, subsequent documents which have been placed is only resignation letter and the leaving letter of the wife. That is petition in the second matter. That is the respondent being was placed. It's only left in the last occasion also it is kept for objection. In the last occasion also it is kept for objection or any of the argument by the petitioner hearing. And production is there. They have never concluded. Then I have completed my argument. It's left to the deciding officer.
So the order passed by this court earlier is on January 23. What is the stage now? No, who are you? You are what? In the family court, you are petitioner.
Is item number 2, my lord, they are seeking to recall one of the witnesses. Income tax officer produces certain document at a very late stage, my lord, which has no relevance with the issues which are framed in the matter. Just to kill the time, my lord.
So the second matter is also related to the same case.
Yes.
Criminal. All right. So what you are seeking in the second?
We will not even speak about anything which is inside the document what we reply for that. We have already concluded. On that application also we have.
Second matter, Kodi.
We have concluded that.
What is it you have filed in the second matter?
Second matter, we have filed an idea for summoning the Commissioner of Income Tax to produce the entire income tax, complete income tax returns page number 216 may be covered.
216. 16.
Not 236. 236. The Commissioner of Income Tax instructs Commissioner to produce a schedule document, separate copy of the income tax return of the complete idea with respect to 22, 23, 23, 24, 24, 25.
This application.
This application was rejected in the month of October, stating that there is a direction by this honorable under the High Court of Karnataka, stating that there is a ending time of November. So this cannot be considered the operating portion of page number 247.
216.
No, this IA5 is filed by you for production of certain documents.
Only complete documents. He has produced only income tax return.
For what purpose you want this to?
Other incomes are also there, which he doesn't want to disclose before the assets and liabilities.
No, the proceedings before the family court or the family court, right?
Yes, family.
Oh, yes. What are those? What is the proceeding? MC case?
Two matters. One is the MC case for divorce, which is filed. In that we have 24 and 25 applications.
So you are the wife in that. So you have filed section 24 application.
24 application and 25 application is also one application. Subsequently, we have filed 25 application also. And the other one, maintenance application, which was filed before last week. This case was originally filed before the Bombay High Court. There was, after the order of the Honorable Appellate Court, it was transferred to the family court, and it was covered with the maintenance application, which was pending with the family court. And it was procedure was going.
All right. Assets and liabilities are filed by both parties.
Assets and liabilities are filed. The only one reason I filed this application is that he doesn't want to disclose the other assets. Is that he doesn't want to disclose the other assets, excluding the acknowledgement what he has. He has produced one acknowledgement where his income contains of 8 crores 80 lakhs odd. But he states that his monthly salary is 8,000 and odd. So it doesn't even match us. It's about if it is divided by 12. So it doesn't even match us. It's about if it is divided by 12, it comes to around 60 lakhs. So I thought for other about 8 lines top from the bottom. It is good to suggest that I have stated my salary as 8 lakhs 80,000 in my assets and liabilities, which was filed on 3/6/2024. Witness further states that I stated salary after April 2024. Further,
Doesn't matter. It will have a bearing. It is your affidavit.
yes, it is there.
Your cross-examination. Are you disputing this? Okay. Yes.
Further, in the cross-examination dated 14/10/2024, at this page number second, serial number 16. Same cross-examination. It's a daily
Para 16.
16.
Para 16.
16. Whether what is the source of your income other than the salary received by you? I have explained it to the IT authorities. What is your income from the house property? I have already explained it to the IT authorities. This one suggests that I am intentionally not disclosing my income from the house property. Further, it is similar way he has answered in the next page also, 20, 21, 22. Everything. The issues are not whether I am entitled for divorce or not. There are no issues about my income.
No, there is an application filed under section 25.
Yes, madam. That is disposed of.
Sir, 25, how it can be disposed of? What is 25?
25 the permanent eligibility.
Is it disposed?
No, in the sense, because they loved it along with the application with the 1620. In one liner, they made that application. If we decided that it's a travel right up to the apex court, where it is dismissed.
What is dismissed? 25 is dismissed.
So, they made the applications with the same terminology, section 24, 25 of the Hindu Marriage Act. Application got decided on which we were directed to pay 90,000 rupees per month. Thereafter, we come before this court made the observation that she is not entitled to get anything. Anything in the court before the registry, which we are doing right now.
What happened to the orders on 24?
That is rejected. The court had directed me to keep depositing with the registrar, not to give it.
No. Whether 24 application is allowed.
It was originally allowed, but it was later on modified by this court, whereby it said the money would be deposited in this court. Deposit right.
So in effect, 24 is allowed.
Yes, technically yes, because but my lord, they are like my contention. We stayed only for a very short duration of 6 months. He was earning almost 35 lakhs admittedly. He relied everywhere, my lord, even on both. The IT court was never there framed. Till date it is not framed about whether she is entitled for alimony or not. They never made claim of.
Now, where is the framing of issues in a matrimonial proceedings?
Because the issues are limited.
Where is the framing of issues in matrimonial proceeding? Please tell me.
Because my petition wherein I am seeking divorce, she categorically stated in the written statement.
She has filed any counterclaim?
No, she has not filed. That's what I am saying.
All right, need not file.
No, nothing.
All right.
She, I don't want to want.
Not required, sir. There is a what is permissible is either she can defend it or file counterclaim or seek alimony.
Yes.
Now she is seeking alimony. So why you can't reveal your assets and liabilities as to what are the other source of? Yes.
The observation of the trial court starts from page number 245.
Page number?
245.
In your petition?
No, yeah, item number 2.
That is not your petition.
It is in there. And would appreciate this order was originally passed in the month of October and they are approaching this court in the month of April at time bound.
All right. Two. Yes, read it. Please read 245.
Error number 9, this is backdrop. Having got the parties in link, first to note that both the parties have filed affidavit of objects and liabilities along with the affidavit of objects.
You are the petitioner.
Yes, in the family code as a I'm seeking divorce.
So you have filed salary certificate,
Yes,
IT returns,
I did.
and bank statement also.
Para 10 minor in criminal record number 730/2020 RID or the number 22 in a case of Rajneesh versus Kenya and another, the honorable affects to please to issue final direction to the trial court. In the same decision enclosure 1 affidavit of social liability of non-resident deponent provided, wherein order number 7 read thus. In order number 7 is included in my para 11 as per this observation, parties are required to submit copies of income tax return for the aforesaid period. To put it otherly, petitioner herein is required to produce ITR for 1 year prior to the marriage, 1 year prior to separation, and at the time when the application for maintenance is filed. Admittedly, the date of marriage is 27/2014 and the date of separation is July 2015. And criminal miscellaneous application number 631/2019 is filed by the respondent seeking maintenance in the year 2019. Therefore, the petitioner is required to file ITR for the period 2013-14, then 2014-15, and 2018-19. Whereas in the present application, respondent has sought for ITR of the petitioner pertaining to the year 22-23, 23-24, 24, and 25. This application is silent regarding for what purpose. The ITR for the said period is required for the respondent. The court opined that no valid reason assigned by the respondent to allow this application. It is all out from the pleading. The respondent has not sought for counter claim. They are permanent alimony. In case of allowing this application, it would certainly cause further delay in disposal of the time found matter. Is point number under consideration is alternately negated. Point number 4, review of the finding to point number 1 to 3. This court proceeds to follow. So all these things are considered that means missing inquiry. We got separated in the year 2015 after staying hardly for 6 months together.
When this application is filed?
It was filed in 2019.
No. No. This application, IA5.
In 2014, 2024, 2024 October. They filed at a belated stage and even they filed at a belated stage and even they take 6 months to come to this.
I say that the petition was transferred here. He challenged before this honorable court giving up the assets and liabilities before the magistrate court and also funding court before this honorable court, which was also placed in page number 51 of their petition. It is very clear. Up to date assets and liabilities was challenged. 58, 49, there, number 9. The direction for placing the assets and liabilities up to date was challenged before this honorable court. This honorable court rejected that and fixed the time period of 6 months. That time period was extended for another 3 months, that is another 6 months till November 2024. So meanwhile, I have filed my application in the month of October 2024, which was rejected. I did challenge before this honorable court after that. because there was a time constraint which has the argument has to go on and it has to be concluded. In the month of December 16th December 2024, the Supreme Court extended arguments before the court and I have placed two documents.
On 4th April.
4th April I have completed because another date was given 29th, that was on Saturday. I was not able to present it the court. So on 4th I
So now what is it posted for?
posted now. I have filed two more documents. One is with respect to resignation and one is with respect to the acceptance of the resignation. In the MCPT, in the criminal is what in the cross-examination, the wife has been cross-examined. By cross-examination, it was very stated that the wife employee was informed her to leave the job because she is not communicating and she is not working well. And she is absent because of the court proceedings. So in that moment, she was terminated. Termination was received. It's not a termination; it's a resignation was received and she was terminated. And she was relieved. That two document I have placed. I have also concluded on both that. I have also concluded on both that this written documents will be taken as a final. I will not argue further. And two documents which are being placed before this honorable court, the order will be passed in the final judgment session. So my argument with respect to IA is also concluded. And on same day, 3:30, the honorable court says their reply. They have today is there. Today 3:30 is there. They have to reply for that. If there is no reply for that, the honorable court will take it as a heard and she will pass the bill. Meanwhile, I have moved this matter only because after February 1, I have filed. I have not filed before that because there was no such opportunity. Meanwhile, there was a chance of transfer of presiding officer at the family court in the end of this. So I have I was supposed to do this honorable court and also I was file a return of there also. It is continued. So if they undertake that the complete details will be produced in the next day of hearing before the family court tomorrow or day after tomorrow, the matter will be over. Or else I will do this honorable court because she has to complete it. Or else another 5 months it will be delayed if she was transferred. Once again, we have to start.
Whatever was the legally purpose, they supplied all the documents in the trial. That is what is reported in the rule order. What they are doing, my lord, is a fishing inquiry. We separated in the year 2015. They are asking for the IT written of appeal. They are asking for the IT written of appeal. The 8 years later than that, 23, 24, and 25. That is one condition. My lord, secondly, please see the application what was filed in the lower court. It is on page number 236.
Where is the application of section 24? Please show me that.
216 of my petition. Page 224. One more application is also filed for under section 25 before this one of section.
All right, I have heard you, official. That's what. Read it.
Number 90.4.
Read it.
It says in such a case, adverse inference can be drawn in case party is not providing for the document. Question is what when we read their application. They make out the ground. They do not make out any ground by these documents are needed. They simply preserve nothing but the physical inquiry. And there is no connection with the matter in which is pending before the family court. Order level rule 16 mandates that there has to be some
This petition is filed by the petitioner husband against the wife, seeking for a writ of mandamus for a direction to the learned judge of the judicial magistrate first class Bengaluru city to decide the matter expeditiously.
Subsection 1. It says, even as provided in subsection 2, notwithstanding anything contained in the code of criminal procedure and in the code of criminal procedure or in any other law, an appeal shall lie from every judgment or order, not being an interlocutory order of a family court to the high court, both on facts and law. It's not an interlocutory order, my lord. It was an interim order passed by the high court.
All right, I've heard you. Please hear the order now. You can't interrupt when I'm going to dictate. You should have completed all your arguments before I commence my dictation. Decide the matter expeditiously and to pass such other orders. Full stop. Learned counsel for the respondent is present before the court, as he has also filed another petition in WP 3967 of 2025. He takes notice of this petition. He submits he does not have much objection in the matter being expeditiously disposed of, provided the petitioner complies with the requirements in the 9672.
240. In Bombay, it was numbered as MJ petition. Thereafter, after transfer, it was numbered as MC petition with the family court petition. At page number 240.
Where is this 6470 of 2022? In your petition, you are not enclosed. Where is that petition at least? What kind of... all right, in your petition, where is it?
Petition at 11, page number 11.
So this is that 6470
Yes, that is 647.
of 22. What is the stage in Bardrim? $125. I am getting from the proceedings of section 1 Nimshairis, page 13.1 within bracket Roman 1A of Hindu Marriage Act. The matter is set down presently for arguments to be addressed by both the learned counsels. It is contended by learned counsel for the petitioner that he has completed his arguments, and learned counsel for the respondent has also filed his written arguments. Therefore, nothing much remains in the matter to be done, as it is for the court to pronounce the judgment based on the before which court it is now pending. Where is that order sheet of the first additional principal judge? Therefore, the first additional principal judge, family court, to dispose of the matter expeditiously. Full stop. It is relevant to extract section 21B of the Hindu Marriage Act. Full stop. The Act, though contemplates disposal of the petition filed under the provisions of the Hindu Marriage Act within a period of 6 months, due to overloading and of matters and huge number of pendency of cases, it is literally impossible for the family court to decide every petition within 6 months. Nevertheless, An endeavor will have to be made by the family court to decide the matter expeditiously. In the present case on hand, I'm in agreement with the learned counsel for the petitioner that since the matter has reached almost finality and both parties have addressed arguments, the matter shall be decided expeditiously by the learned judge of the family court and pronounce the orders of, in accordance with law. Full stop. Accordingly, I pass the following. This petition is allowed. The first additional principal judge family court is directed to dispose of MC 6470 of 22. ಎಷ್ಟು ದೂರ ಇಟ್ಕೊಂಡ್ರೆ ಹೆಂಗ ಆಪರೇಟ್ ಮಾಡೋದು. This petition is filed by the wife challenging the order passed by the first additional principal judge family court in MC 6470 of 2022 on the application filed by the petitioner wife and IA number 5. Full stop. This application came to be filed by the petitioner wife seeking issuance of summons to the Commissioner of Income Tax, Principal Chief Commissioner Income, summons to the Commissioner of Income Tax, Principal Chief Commissioner Income Tax, Central Revenue Building, Queens Road, Sivajinagar, Bengaluru, for production of certain documents, namely income tax returns pertaining to 2022-23, 2023-24, for the family court to advert to these documents which are not placed before the court, which is now being sought to be produced for deciding the permanent alimony which is claimed by the petitioner wife. Full stop. Therefore, this application is relevant and necessary for deciding the alimony that requires to be awarded in favor of the petitioner. Full stop. Hence, he seeks to allow the application consequently set aside the order passed by the learned judge of the family court. Full stop. Per contra, learned counsel for the respondent vehemently contends that the assets and liabilities by both the parties have already been filed for the family court. On the application filed by the petitioner wife under section 24, read with section 25, the same came to be allowed, and on challenge made to the said order, this court has modified it and directed the respondent to deposit the amount before this court, before the family court. Full stop. Learned counsel for the respondent further submits that as per the judgment of the apex court in the case of Rajneesh versus Neha, reported in so and so, he has complied with the requirements and produced the salary certificate, IT returns for the relevant period, and also the bank statements. Therefore, there is nothing that is required of the respondent to produce any material as sought for by the petitioner. In view of the respondent having complied with the requirement as per the case of Rajneesh versus Neha, it cannot be said that the document sought for by the petitioner, which is inconsequential for deciding the matter on hand, requires to be produced merely at the asking of the petitioner. Full stop. Learned counsel further contents not be required for deciding the petition on hand before the family court. Under the circumstances, it has rightly rejected the application, which does not call for interference. Full stop. New paragraph. I have heard learned counsel for the petitioner and respondent. Apparently, it is not in dispute that both parties have filed their assets and liabilities. It is also seen by the impugned order that the respondent has filed the necessary documents and details and as required in the and stipulated in the case of Rajneesh versus Neha by the Honorable Apex Court. Therefore, the documents sought for in IA number 5 by the petitioner under Order 11, Rule 16 may not be required for deciding the petition on hand, and also the permanent alimony, if at all, that would be considered by the family court. Under the circumstances, I do not find any good ground, cogent reason to agree with the learned counsel for the petitioner. Consequently, it is negatived. Accordingly, I pass the following order. This petition 7/2 of 2025. The family court is directed to dispose of the matter on or before 2nd May 2025.
Morning.
You met? Yes, what happened, Mr. Senior Counsel?
Please, Milad. Quick submission, Milad. As Milad rightly suggested by this court, we offered, Milad, we're going to withdraw domestic violence matter, we'll have to withdraw 307 also, and also we're not claiming maintenance also. Milad, his case is that, Milad, custody should be given to them, and he is not ready to pay any maintenance, Milad, for the child, Milad. For last 2.5 years, Milad, we have not seen the face of the child also, Milad. We requested him to, Milad, consider all this, deposit some amount that we are not going to take any, Milad, withdrawal, Milad. Let the money, Milad, accrue up to she attains the majority, Milad, and you are not going to, because you are also, Milad, gainfully employed, Milad. We are taking care of it, Milad. Little adamant, Milad. Only my request is, Milad, is it possible to, Milad, have this in the in-camera proceedings tomorrow, Milad, 2:30, Milad?
I am already burdened with so many.
Probably, Milad, the intelligence of this court may, otherwise, Milad, 2:30 tomorrow, Milad.
Tomorrow it may not be possible.
Milad.
Tomorrow it may not be possible. Maybe on 15th you can try. Yes, 15th. Then in the meeting the 15th.
Please.
We have a bench. We'll keep it at 5. Tomorrow it may not be possible. You can try on 15th. Though I am in a bench.
Please, it's convenient to the court.
So you can represent, file exemption. You represent there that the matter is seized before this court.
For the mother, it is there. Huh? Mother is also drawn into the garb of the proceedings.
No, whether she has taken bail.
There is bail. Bail is there. Only she's on anticipatory bail. She'll have to apply for a regular bail that day to the court. Is what he says.
They will not precipitate the matter. It will not precipitate the matter till 16th. Anyway, you can be present here.
Very well.
You do whatever is required there. You can tell the matter is seized before this court. You can come at 4:30 on request, Berkoli. At request of both learned counsels. Counsel for the petitioners also is present. Counsel for the petitioners, Sri Sardananji Shastri is present. Learned senior counsel Sri Chandramouli for Saksha Bhagwan is present on behalf of respondent. So also both the parties, that is petitioner and respondent, are physically present before the court. At request of both the learned counsels, the matter is shall be listed on 16th at 4:30 p.m. to be called in chamber.
Great.
My Lord, interim order may kindly be.
Interim order stands extended till next date of year.
Highly obliged.
Yes, what do you say about the summer vacation?
Summer vacation, the only request we had was in the month of April, instead of 50% being taken as the 1 to 15 days, if that be considered only on weekends, the weekdays tuition classes can be completed in the month of April. In the month of May, 50% can be equally divided as what we have sought for.
Sorry, please repeat that again.
My Lord, summer vacation is for both April and May months.
the child needed additional tuition classes. Therefore, all in my writ petition pleadings also, all I am seeking for is only for summer vacations. Winter and Dasara 50% have not challenged. Only for summer vacation, the 50%, if April is modified to be weekends and May as 50% vacation between each of the parties, we are okay with that. That is only owing to the tuition classes that needs to be conducted, because now the child is shifting from 3rd standard to 4th standard and he is still in the process of learning writing properly, and the tuition classes has helped him in the 1st and 2nd standard, and 3rd standard has improved his performance. He has covered the lacunas he had in reading capability. Is the delayed part now. So if this summer vacation, April weekdays, if we are allowed to continue the tuition classes, weekend was that since the tuition classes, the marks cards of the child has been produced at Annexure T series, it is due to owing to the tuition classes that when the child's education was extremely bad, did not have reading, writing, learn any of those capabilities. Now, owing to the private tutor coming home and taking classes, it has covered up in reading and analytical skills. Only writing has to be covered up.
That she'll cover it.
The only modification
that deficiency she'll cover it. She's mother. She is more interested than you.
My lord, what has happened in this case is, my lord, as long as the child was in her custody till November 2022, and have produced documents to show how even after the child being in her custody, the child's education has not improved. And only after the child has started this private tuitions, it has improved. I am not asking for the entire modification. In the month of April, every weekend from Saturday and Sundays, the mother visitation I'm seeking can be continued. Only in the month of April, I'm seeking that weekdays I may be permitted to continue the classes and weekends may be given to her. May can be divided 50-50 as per the order.
My lord, I just want to tell about the marks cards. This time the marks cards have come out and he is under satisfactory on all the parameters. There's no great improvement wherein there's excellent or good remarks. When I was there with the child till 2023, he had good remarks, excellent, and he was doing well. This time all his subjects, EVS, maths, English, everything I could see only satisfactory, and they have told the child to improve. I don't
This
think
for which year?
This year, my lord.
That is 24.
Yes, that is 25. This March, the marks card.
You're talking about academic year 24-25.
Yes, yes.
So when did he separate from you?
23, November 23.
So before that, how was his report?
It was much
Needs
better than
needs
what has come out
attention,
now.
my lord.
What has come out now, it was much better than what has come out right now. So he was doing much better with me
But
because
where
I
is
was.
that report? You have the report of that education.
I have it in my phone. I can produce it in the next.
My lords, I have produced the marks cards of the years 6.
There is no quantitative marks.
1 minute, let us speak. Yes, madam.
And this is from page number 236, my lord, till page number 241 is the marks card of the first term when the respondent was residing with the minor child. If page 241 is taken, everything is at the status of needs attention and satisfactory. From page number 254 is when the petitioner or the respondent had left the petitioner and the child, and each of the marks card from needs attention category, it has shifted to satisfactory category. That is also that is exactly the statement what I am also making.
So you are blaming each other for this?
No, I am
Needs
blaming that
satisfactory.
from needs attention, it has moved to satisfactory. All I am saying is there is extra tuition classes with a private tutor who's skilled to teach children, who's coming home to take extra classes with the help of the teacher. Now the performance is improving. From needs attention, it has come to satisfactory. Now, if it is continued in this vacation, be coming to 4th standard, they will learn, because after 7th standard, the automatic promotion
Which class the child is in?
now it is coming to
Of your education, if you don't have culture, values and ethics and other
My lord, coming to
basic
culture,
fundamentals.
values and ethics, if the mother is abusing the child, hitting the child for speaking truth in
We'll see, we'll
court,
transfer the custody, then we will see how the child behaves. Arcoli.
My lord, one more submission. 17th is my child's birthday, April 17th. So if I'm given this month as continuation of my 50%, then fine. Otherwise, 17th, at least half day, I want to cut the cake and fine. Otherwise, 17th, at least half day, I want to cut the cake and celebrate with him.
So as it is, the family court is ordered for 50% of the vacation,
Yes,
which
my
is
lord.
questioned by you.
Yes, my lords. Family court has ordered for 50% of vacations. I am questioning only with respect to this academic year's summer vacation owing to this academic year's summer vacation owing to and saying that I need to continue a tuition class in the month of April.
All.
And in the prayer column itself, I have restricted to that.
This petition is filed by the father against the mother of the child, minor child. Namely Maurya, aggrieved by the order dated 24th January 2025, passed on
Number 6 and IA number 7 is what I
PA number
have filed.
6 in GNWC 44 of 2024. Full stop. The learned judge of the family court, by its order dated 24 January 25, passed an order granting weekend custody of the minor child Master Maurya from Friday after school timings and permitting the respondent herein mother, to pick up the child from the school and spend time with the child till Sunday 7 p.m. and to drop the child back to the house of the petitioner. Full stop. The respondent mother was also granted 50% of all school vacation. This is Dasara, Deepavali, summer and Christmas vacations. And the remaining 50% was granted to the petitioner father to spend quality time with the child. Full stop. It is a vehement contention of learned counsel for the petitioner that the impugned order is bad in law, as the custody during summer vacation has been ordered at 50%, which may not be appropriate considering the present status of the minor child. So also, it is contended that the weekend custody granted from Friday to Sunday be shifted from Saturday morning to Sunday evening, so that the minor child Maurya can attend to his tuition classes on Friday evening, which is already scheduled and is undergoing for the present. It is vehemently contended by learned counsel for the petitioner is not comfortable with the mother. And due to the harassment meted out to the minor child by the mother, he does not intend to spend time with the mother and likes to spend time with the father. It is also contended by learned counsel that presently the minor child is in the 4th standard and he is
Going to fourth standard.
going to 4th standard and presently he attends to tuition classes during the weekend, that is on Friday evening, hence the
All
weekend.
weekdays.
Huh?
During all weekdays, Monday to Friday.
Going for tuition classes on every day.
Every weekday, Monday to Friday, he has tuition classes. When the school is operating, there is only 2 hours of tuition classes. Now, since the vacation has begun, he's attending 4 hours of tuition classes from Monday to Friday.
That is attending tuition classes from Monday to Friday. Therefore, if the custody and visitation rights are given to the mother, the tuition classes and his studies will get interrupted, due to which the child may not fare well in the academics. Full stop. It is also contended by learned counsel for the petitioner that the minor child has been faring reasonably well after he is attending the tuition classes. Attend to his tuition classes. Full stop. Next para. Learned full stop. Next para. Learned counsel further contends that the minor child is interested in and has passion towards football. Is also interested to pursue as a career in future. So the father has been taking the minor child for practice session, will disturb the routine and curriculum of the minor child. Under these circumstances, it is contended that the impugned order passed by the learned judge of the family court is set aside, and the weekend visitations be granted from Saturday morning to Sunday evening. And so also the summer vacation, the 50% of the vacations may be exercised by the respondent mother.
Who should pick and drop the child, my lord? Because I'm harassed at their door.
This is your contention?
This is my contention.
Yes.
So, like, what time do I go and pick up the child on Saturdays? Because once I go there,
Madam, you don't interrupt when I'm dictating. If you agree, you finished your argument, you allow me to dictate. New paragraph. Per contra, the party in person, mother appearing herself, contends that the minor child was living with her activities. If there is any drawback, shall be adjusted, and she will take care of the needs of the minor child. It is also contended by her that she would work from home and she would take care of the needs of the minor child. Full stop. With regard to the summer vacation, the party in person mother contends that the summer vacation has already begun from 1st April 2025 and the school would start functioning from 1st June. Therefore, 2 months of vacation, that is April and May, are available, which has to be given 50% to the mother as per the impugned order passed by the family court, which has not been now allowed in view of the petition being pending before this court. Full stop. Therefore, she contends that the petition filed by the of this petition. Full stop. New paragraph. I have heard the learned counsel for the petitioner and the party in person, respondent mother. Apparently, it is seen and there is some dispute inter se between the father and the mother, who are the husband and wife. Consequently, the vacations, and all school vacations, including Dashara and Christmas, which is granted by the family court, 50% to the father and 50% to the mother. But with regard to the weekend custody, which is granted from Friday to Sunday 7 p.m. after school, Friday after school hours to Sunday 7 p.m. This court, considering the fact that the minor child is going to attend tuition classes on Friday, deems it appropriate to modify it from Saturday morning 10 a.m. to Sunday evening 7 p.m. The child shall be picked up child shall be dropped by the petitioner father to the residence of the mother, and the child shall be dropped back to the house of the petitioner by the mother. Full stop. Coming to the issue of 50% of all petitions. In the case of child custody matters, when the custody is with the one of the parent, the non-custodial parent is eligible and entitled to have reasonable custody and visitation rights in order to see that there is proper development, growth, and psyche of the minor child, to have love and affection of both the father and the mother. When the minor child is spending the whole week with the father, it becomes the duty of the father to become one copy. You can't keep asking my file. Has dealt with this issue of non-custodial parent having custody and visitation rights. So also a coordinate bench of this court has passed an order. Therefore, this court, relying on the judgment of the division bench of this court, wherein certain guidelines are issued, this petition is disposed of in a similar manner. Accordingly, I pass the following order. This petition is disposed of with the following observations. Full stop. The minor child, Master Maurya, shall be picked up by the respondent mother from the petitioner shall drop the minor child to the house of the respondent mother on Saturday morning at 10 a.m. and the respondent mother shall drop the child back on Sunday at 7 p.m. on all weekends. Full stop. The summer vacations of 50% shall stop. The summer vacations of 50% shall be spent by the father, directed to pick up the minor child from the house. You can go and pick up the directed to pick up the minor child from the house. You can go and pick up the minor child.
Today, my lord.
Not today. He has to be briefed. He has to be told. What is today's date?